One.
Your Honors, good morning.
Morning.
Welcome to the first ever online public panel interview by the Judicial and Bar Council of candidates for the position of Chief Justice of the Philippines, vice the retiring Chief Justice Diosdado M. Peralta. But before proceeding, let us have first the centennial prayer for the courts, the Philippine National Anthem, and the Supreme Court hymn.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Bayang magiliw, pelos ng silanganan, alam ng puso, sa dibdib mo'y umay. Lupang hinirang, tuyang ka ng magiliw, sa manlulupi, kita masisingil, sa lagat at bundok, sa simoy at sa langit mo lahat. Ay ilang ang tula at awit sa paglayang tinamahan, ang isang ng watawat mo'y nagumpay na nagiging, ang bituin at araw niya kailan ang ating magdidilim. Lupa ng araw na maraming pagsika, layalangin sa likod. Aming ligaya naman may mamagin, at namatay ng dahil sa'yo.
Or just to arise, in my distress.
Uphold the fundamental law, from the spring of judgment's throne. With conscience free their views to air, they know and to all declare,
Your Honors, again, good evening. May I present to you the members of the Judicial and Bar Council. The Honorable Chief Justice Diosdado M. Peralta, ex officio chairperson of the JBC, representing the judiciary. The Honorable Secretary of Justice Minardo I. Guevara, ex officio member for the Executive Department. The Honorable Vicente Veloso III, ex officio member for the Legislative Department. The Honorable Justice Jose Catral Mendoza, chairperson of the Judicial and Bar Council Executive Committee and regular member representing the retired members of the Supreme Court. The Honorable Judge Toribio Ilaw Jr., regular member representing the private sector. The Honorable Justice Noel Jimenez Tiham, regular member representing the Academy. And the Honorable Judge Franklin J. de Monteverde, regular member representing the Integrated Bar of the Philippines. May I refer you to the Honorable Chief Justice to officially open the proceedings.
I now declare the proceedings today open.
Your Honors, the candidates for interview are the following. Senior Associate Justice Estela Marcelino Perlas Bernabé. Associate Justice Alexander Dahon Gizmondo. And Associate Justice Ramon Paul Layugan Hernando. Your Honors, the first for interview this morning will be the Honorable Senior Associate Justice Perlas Bernabé. May I request Madam Justice to please rise and raise your right hand so that I can administer the oath. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial and Bar Council?
I do.
So help you God. Thank you, Madam Justice. You may now take your seat. The first to interview the candidate will be the Honorable Judge Franklin J. de Monteverde.
Thank you, Attorney Ed.
Thank you, sir.
Good morning, Justice Bernabe.
Good morning po.
How are you today?
I'm very fine.
Okay. Now, this is the second time that I will be interviewing you for the past 1.5 years, all right?
Yes.
We
Right.
first interviewed you sometime in 2019, also for the same post.
Yes.
Okay. Now, since that time, the first time that we interviewed you, has there been any change in your credentials?
Yes. I now head the Senate Electoral Tribunal, and I'm now a chair of the second division.
Okay.
And I'm now the president of the Philippine Women Judges Association.
Okay. Now, just to break the ice, can you highlight some achievements that you have made for the past 2 years,
For the past
aside
2
from those
years,
that you mentioned earlier?
yes, I have already been in the court at the time, and I have made some landmark decisions in the court, and I came out with some, I spearheaded some rules in the court, like the Philippine Deposit Insurance Corporation rules, as well as the cyber warrant rules.
Okay, one of the concerns that we have right now is the health and well-being of judges and justices who aspire for vacant posts. The reason for this is to ensure the capability and the effectiveness of the performance of such aspirants. My question is, are you healthy, Justice Bernabe?
I am very, very healthy. I am fit to be promoted to the position of the Chief Justice.
You know, I asked this question because in the past we have aspirants who say that, who said that they were in the pink of health, but then after a few years they succumb, they suffer a heart attack and other illnesses. Now, are you sure that you are in the pink of health and that you can ensure the effectiveness of your performance should you be appointed as the Chief Justice?
I am very, very sure, Your Honor, and my medical certificates could attest to that.
Yes, your medical certificate says that you are physically and medically fit, but your blood chemistry shows otherwise. Your total bilirubin, indirect bilirubin, cholesterol, LDL cholesterol, which is a bad cholesterol, and glucose are high. What can you say about this?
They're just minimally high, Your Honor, and I've checked already with the doctor. The bilirubin is just caused by some maturing red blood vessels, and the glucose is because of rise in age, and it's not really so much, as well as the cholesterol. It's just a minimal increase in the normal level.
Are you not a diabetic, Justice Bernabe?
No, Your Honor, and we do not have that in the family.
You are not taking any medications for that matter?
None, Your Honor. I'm not taking any medication for any illness, even the blood pressure or the rise in the glucose.
Okay, let's go directly to your vision for the judiciary. Should you be appointed as Chief Justice, what do you intend to focus on?
Your Honor, I have given my short-term plans and long-term plans of action, which I submitted to the Judicial and Bar Council, and they're all listed there. What are the short-term plans I wish to pursue, and also the long-term plans. Do I need to discuss all of them, Your Honor?
Yes, for the benefit of the public.
Can I just brush
Go over
on
your
my
notes.
notes?
Okay.
Yes.
By all
Well,
means, Justice Bernabe.
Yeah. First of all, my purpose is really to enhance the efficiency of the judiciary, and I will do this through automation or computerization of court processes, the special projects or initiatives for case decongestion, and I will streamline the internal procedures and organizational development and evaluate the needs of the Judicial and Bar Council, as well as the Philippine Judicial Academy, as well as the responsiveness of the judiciary to the public health crisis. Because I believe that the efficiency of the judiciary would be more if it will be able to fulfill its duty to dispense timely and meaningful justice. And since I will be serving for only a span of around 1 year, then I plan to create an advisory council composed of the 5 most senior justices, just to ensure the continuity of plans and programs which I will pursue. And the first one...
Justice Bernabe, excuse me. Given that period of time wherein you will be spending in the Court of Appeal, should you be appointed as a Chief Justice, would you say that your long-term plans can be implemented, given the period of 1 year only?
Yes, Your Honor. I cannot say that for sure, but I would be able to lay the institutional groundwork for all these plans so that it will be continued by my successors.
Okay, what are those long-term plans of yours?
Insofar as the automation or computerization are concerned, my long-term plans would be the full implementation of the Enterprise Information Systems Plan, which was adopted in 2014, but not really pursued. And I will also prioritize the Management Information Systems Office Reengineering Development Plan, because right now we have a few personnel in the MISO, our Management Information Systems Office, and we need IT personnel to handle all the digital initiatives and concerns of the court. Now, for the special projects or initiatives for case decongestion, my long-term plans would be the creation of other rules of procedure apart from what has been released already by Chief Justice Peralta. And also, I will evaluate the judicial audit system of the court administrator to better monitor the performance of the judges of the lower courts. Now, insofar as the streamlining of internal procedures and organizational development is concerned, my long-term plans would be to re-engineer the structure of courts distribution in the country, considering the present imbalance in caseloads, existing personnel, and the populations to be served. Also, we will evaluate the personal needs of the Supreme Court's various units, and monitor also the implementation of the Judicial Integrity Board. And also, I will create a system to stabilize court decisions in view of conflicting jurisprudence.
Justice Bernabe, you mentioned the Judicial Integrity Board. Just what is this?
The Judicial Integrity Board has just been newly created to prevent corruption and to strengthen the integrity of all the court officials and employees of the court.
Would it include lawyers, considering that it is a Judicial Integrity Board?
No, it will only involve investigation of court officials and employees of the court, including the court administrator and the deputy court administrators.
What about judges?
Yes.
Ms. Bernabe.
Yes, Your Honor. All administrative complaints against them will be handled by the Judicial Integrity Board, except, of course, those which are below the rank of grade 26, which can be endorsed to the court administrator's office.
Okay. Chief Justice Peralta has been doing a great job insofar
Yes, I agree with
as
that.
managing, the Supreme Court. Not only the Supreme Court, but also the JBC, the PhilJA, and all the officers under him.
Yes,
He's
Your
a
Honor.
hands-on
I agree with
Chief
that.
Justice. Okay. Would you be one?
Yes, Your Honor. And I'm willing to really face head-on even the most serious problems of the court, such as the revamp of the organizational structure of the court, as well as the court's needs for automation and computerization.
Okay, Justice Bernabe, you spoke of your long-term plans. What about your short-term plans, which can be implemented, I believe, within 1 to 2 years?
Yes, Your Honor. For the short-term plans for the automation and computerization, I would go for the computerization of basic court processes like the fully functional e-filing, e-raffling, e-calendar, e-payment, and the automated trial system. I would also go for the continuation and improvement of the video conference hearings to the Judiciary Office 365 or other suitable platforms. And I will, of course, address the connectivity concerns of all courts nationwide and the personnel within the Supreme Court's Management Information Systems Office, as well as I will work on the promulgation of the rules on electronic notarization. That is for the automation and computerization, Your Honor. But for special projects or initiatives for case decongestion, I would go for the implementation of the Judges at Large Act and work towards the full implementation also of the Family Courts Act. I will increase the competency of the courts by providing judges with a complete and updated framework of template orders and decisions. And for the Supreme Court, I might create a pool of lawyers to assist them in the resolution of the age cases. And I will also conduct a study to expand the scope and increase the claim thresholds under the court summary rules of procedure, as well as the small claim procedure, and ensure the completion of already pending rules, such as revisions to the rules of criminal procedure and the rules implementing the Family Courts Act. And lastly, for the special projects, I will evaluate and computerize the OCAS reporting and data analysis process. Now, for the streamlining of internal procedures and organizational development, in view of the OCAS role as the backbone of court administration nationwide, then I will evaluate the OCAS functions and hire the necessary ICT personnel in line with the computerization programs of the court and streamline its liaison mechanisms with other judiciary units. Also, I will work to streamline the internal court procedure in the Supreme Court in order to expedite the release of promulgated decisions or resolutions, update the internal rules of the Supreme Court to codify current court practices, and evaluate the judiciary public assistance sectors, which was spearheaded by our Chief Justice to see to increase more the access to justice by the Filipino people. And for the PIRJA, I will address the personal needs. I will examine the revised curriculum of the PIRJA for the training of the judges, and for the JBC, we will also address the personal needs of the JBC and revisit the internal rules.
Now, among your plans and programs, can you cite at least two of those that you will be implementing in the short space of time that you will be there as Chief Justice, that would properly leave a lasting difference for you?
I would go for automation or computerization of basic court processes, like the e-filing.
Can you explain further, Justice Bernadette?
When I go for the automation or computerization of basic court processes, the court will have an e-filing system, which means considering the pandemic at present, then there will be more access to justice by the litigants and the lawyers, considering that they could file now their pleadings online, although they've been doing this already through email. But I am speaking of some kind of an electronic courts that would make it really fully functional for all courts. And then we can have the e-drafting, although this is also being done by the pilot courts, but it doesn't hold true for all the other courts. Now, for the automated trial system, this will expedite the court proceedings because the judges will not be able to really give out a spot order, which the litigants, which the lawyers can bring home, and this will dispense with the delay in the sending of the notices. Now, the second one is, since this is really pandemic, this, of course, this, when I say computerization and automation, this would include the addressing the connectivity concerns of various courts nationwide. Now, for the special projects for case decongestion, since the congestion is really a perennial challenge in the judiciary, then we will implement the Judges at Large Act as well as the Family Courts Act, so that there will be more judges deployed, which will expedite the disposition of cases.
Okay, Justice. Sometime in 2018, an article was written about you entitled "The Accountability of Supreme Court Justice Bernabe. Are you, or have you read it?
Yes, Your Honor.
Okay. A portion of that stated, quote, Bernabe often votes with the new ones. She is respected in the High Court because of her collegial virtues, unquote. What does this article mean to you, and how do you go about your decision making, especially in terms of high-profile cases?
I cannot really say that I am an unpredictable judge or justice because I base my decision on the merits of each case. So if that is my judicial philosophy, basing it on the merits of the case and applying laws and jurisprudence to the facts of the case, I would say that I am very predictable. But of course, I think the unpredictability would relate only to the cases that are political in nature. So I do not really fully agree that I am an unpredictable justice.
Among the three aspirants for this post, Justice Bernabe, you are the most senior, and not only that, you are going 69. So assuming that you will be the one to be appointed, you merely have 1 year to perform effectively. With this background, would you say that you have an advantage over the other two aspirants in terms of length of service in the Supreme Court and in terms of your age?
Okay. I would say that yes, I have an advantage in the sense that during my 9.5 years of service in the Supreme Court, I have more experiences in terms of judicial and administrative works. Judicial because I've been working on all my cases for 9.5 years, and administrative because I've been involved in so many administrative works, being chairman of the subcommittees on commercial courts, chairman of the subcommittee on family courts, chair of the second division, chair of the Senate Electoral Tribunal, and I have various activities to attend to, like I am the president of the Philippine Women Judges Association and also the co-chairperson of the technical working group on cross-border disputes involving children. So I think in terms of experiences, I have more because of my longer stay in the Supreme Court.
Okay, Justice Bernabe, kindly define leadership.
Leadership is a position that would give you the opportunity to set the policy directions of the court, and it is an opportunity also to create or bring about an institutional change. When you are a leader, then you will be more in a position to see what directions or what policies, plans, and programs you would want to pursue under your leadership.
So, given that definition, what kind of a leader are you? Are you a compassionate one? Are you a leader by example? Are you firm? Are you decisive?
I am a leader by example in the truest sense of the word. My track record would speak for itself that I have been with the Metropolitan Trial Court as my first judiciary appointment, and I rose up from the ranks to the RTC position, Court of Appeals Justice, and now to the Supreme Court.
Okay, Justice Bernabe, that was my last question. Thank you for your time and good luck.
Thank you, Your Honor.
Thank you. Thank you, Judge. The next to interview the candidate will be the Honorable Justice Noel Jimenez Tiham. Justice Tiham, sir. Attorney Lea, andyan ba si Justice Tiham?
Channel 4. Channel 4.
Your Honors, Justice Noel Jimenez Tiham got disconnected. In the meantime, we will proceed to the next interviewer, the Honorable Judge Toribio E. Ilaw.
Okay. Is Judge Ilaw ready? Judge Ilaw?
Yes, sir.
Okay, the next to interview the candidate will be the Honorable Judge Toribio Ilaw Jr. Judge Ilaw, sir.
Yes, thank you, Attorney Aricheta. Yes, good
Yes, sir.
morning, everybody. Yes, good morning, Justice Bernabe.
Good morning, Your Honor.
We had extensively interviewed in the past. In fact, you had been shortlisted twice. That was for Chief Justice October 2, 2019 and November 23, 2018. But you were not, unfortunately, appointed. Do you think you will be appointed this time?
I defer to the presidential prerogative to appoint Your Honor, but I hope to get appointed.
All right. How do you perceive titles or positions? Are they important?
Your Honor, to me, are you referring to the position of a Chief Justice, Your Honor, just the in general titles?
No, because I observed that all correspondences coming from your office should contain Senior Associate Justice.
Because that is the title that I have now, Your Honor, but to me, I equate title to responsibilities. So I think the title is not as important as the responsibilities attached to the position.
All right. If appointed, you will be the chairperson of the Judicial and Bar Council. Have you thought of some projects that you will pioneer in this council?
Yes, Your Honor. I think I would digitize the records of the Judicial and Bar Council so that the requirements for the applicants would not be repetitively asked. And also with the projects that I have in mind, like the Judges at Large Act and fast tracking also the implementation of the Family Courts Act, I think we would need more personnel within the Judicial and Bar Council to expedite the processing of the applications for judicial positions.
How will you lead the council?
I will be leading through collaboration. The officials of the Judicial and Bar Council, including you, Your Honors, will be asked to suggest how we can improve further the office of the Judicial and Bar Council. So it's going to be, my leadership is going to be through a meaningful collaboration with you.
All right, you stated as your long-term plan your intention to create a system of stabilizing court decisions, emphasizing in view of conflicting jurisprudence. How would you do this?
I will coordinate with law schools, Your Honors, and ask them to analyze court decisions. And since law schools are more concerned of the history of cases, they would be able to easily identify which decisions are conflicting and which are not. And they would present to the court these jurisprudence. When the time comes for the proper case to come to the court, then we can overturn or we can choose which decision is really one that is more adhering to the Constitution and the law.
That is shifting such responsibility to the schools. How about, would you
No, Your
look
Honor.
after the ponencia?
It's
Yes,
just
please.
going to be an analysis, Your Honor. They will not suggest anything. It's going to be just tracking the history of cases.
Don't you think that will be or dangerous to having gravely criticized your the ponencia of your fellow justices? Imagine just to inform them of their perceived inconsistent ruling.
I don't think so, Your Honor. I think most of us, the members of the court, would really want jurisprudence to be stabilized.
By the way, what do you think is the foremost purpose of a Chief Justice?
The purpose of a Chief Justice, Your Honor, is just to really set the plans, programs, and initiatives of the court, put them into motion, implement them towards the vision of having a court that is responsive to the needs of the people, a court that is independent with integrity and unified.
One of your short-term plans is stated that is to streamline internal court procedure in the Supreme Court to expedite the release of promulgated decisions, resolutions. Could you explain this further, please?
Your Honor, when we promulgate decisions at present, it takes a long time before these are released. And I've checked on it and saw that it stays with the Office of the Justice for a longer time than usual because of the proofreading. And then after proofreading, it comes to me, and there is another process of proofreading, and it goes to the Division Clerk of Court, who also proofreads these decisions. So it takes a longer time, probably 1 or 2 months, to get these decisions released. So I want to streamline this court process and evaluate the problems and see what I can do to effectively release them without delay.
Alright, do you think that a Chief Justice is a justice of ordinary motivation with extraordinary institutional prerogatives? That is, a Chief Justice who is motivated by some personal taste in legal reasoning, but has tools available to advance his her interests, which are not normally available to other justices?
No, Your Honor. I don't think the position of Chief Justice would call for advancing personal interest. It is just like any other position of an associate justice where you have to really do your functions by as interpreting law in accordance with the law and the Constitution. And insofar as administrative works are concerned, it should be beneficial to the welfare of all the litigants, the parties, and the employees.
Chief Justice John Roberts is said to adhere to prudentialism as he takes limits on judicial authority seriously, appreciates the need to respect the tasks and authority of other institutions of government, and whose general watchwords as a judge are modesty and humility. If appointed, what judicial ideology or philosophy would you espouse?
Judicial philosophy in terms of deciding the cases, is that what you mean, Your Honor? Because that is our duty to decide our cases. So my judicial philosophy would just be, I can just be a textualist. When the law is clear and the intent is clear, I interpret the law in accordance with the law and the intent of the framers. But when the law is vague and the intent could not be determined from the framers, then I would apply reason and logic, the societal implications of the ruling, and also the fairness, most of all, of the court's ruling.
All right, there's a pending case before the United States Supreme Court involving free exercise of religion and free speech. A nonprofit adoption and welfare agency was barred by the city of Philadelphia from placing children in foster homes because of the agency's policy of not allowing same-sex couples to be foster parents based on religious grounds. Because of this, the agency sued the city of Philadelphia and argued that each policy is an exercise of its right to free exercise of religion and free speech. So if this case is brought before you, how would you decide it?
Can you repeat the question again, Your Honor? It's quite a long question.
This is, remember the case of Fulton versus City of Philadelphia? Have you come across
No,
this
I'm
case?
not familiar with that, Your Honor.
All right, anyway, let's go to another subject. The judiciary is an institution dedicated to public service. How would you ensure the quality of service rendered by the judiciary under your leadership?
Your Honor, of course, I assume that all the employees, all the officials, the judges, especially the judges appointed by the Judicial and Bar Council have all been vetted. The applications have all been vetted, and they are supposed to be persons of integrity, probity, competence, and independent. And therefore, Your Honor, I have that assumption, and if ever there are complaints against them, we have accountability mechanisms in place, like have the Judicial and the Judicial Integrity Board, and we have the JPAS, the Judicial Public Service Sector, created by the chief, so that all complaints can be through these agencies. And also, Your Honor, we also have the field jam, where judicial ethics should really be taught as the cornerstone of the judgeship position. And I think trainings on anti-corruption measures should also be addressed by the Philippine Judicial Academy.
Alright, in your dissenting opinion in People versus Pagal, you stated that our current procedural framework must be revisited so as to codify the proper searching inquiry guidelines and other relevant procedures the trial judges must follow whenever an accused pleads guilty to a capital offense. So aside from guidelines on searching inquiry, what other amendments to the rule on criminal procedure do you think would be necessary?
Your Honor, I think the Chief Justice has already spearheaded the rules on criminal procedure, and it's going to come out very soon. So can we just await, Your Honor, the amendments to these rules?
Any additional amendments that you would suggest in line with your dissenting opinion in that People versus Pagal?
Your Honor, this involves the let me refresh my memory, Your Honor. I think in this case, I was asking for the remand of the case to the lower court to be able to, for the court to conduct a more searching inquiry about the plea of guilt of the accused in a capital offense. So I think this was, I think, done before well, Your Honor, I think the judge should really be more detailed in his questioning on whether or not the accused understands the consequences of his plea of guilt to a capital offense. So there should be more guidelines and more questions, not just the pro forma questions that the ordinary judge would ask of a person accused of capital offense.
Because just to refresh your memory, Justice, in the said case of People versus Pagal, the Supreme Court, through the ponencia of Justice Alex Gismundo, ruled that an accused plea of guilty alone to a capital offense does not amount to a judgment of conviction without evidence of proof beyond reasonable doubt. So you mean to say that you go as far as this ponencia of the Supreme
Your
Court
Honor,
in this
yes,
case?
no. Because in this case, the prosecution was not able to present any evidence anymore because, first of all, there were the complainants, I think, were not informed of, they were not subpoenaed on this case. And there were so many resettings of the hearings, but none of the complainants appeared because they were not notified. So my suggestion here was to remand it to the lower court and give the complainants the opportunity to really present evidence to prove the guilt of the accused beyond reasonable doubt. It is not the fault of the complainants that the prosecution was was not able to inform them that hearings were going on. That's why I wanted a remand of the case. And the judge, I think, should be more cautious about this, that the negligence of the prosecution should not bring about the acquittal of the accused charged with a capital offense merely on the basis that there were the complaining witnesses were not given the opportunity to present their side.
If we're going to follow your dissenting opinion, simply you're going to remand the case. That is this for trial de novo. Are
Yes,
we
so,
going to go back
to give the prosecution a chance to present their evidence, because in this case there was no evidence at all, and I think the complaining witnesses were not even notified of the hearings that were set by the court.
All right, let's go to another case. In the case of Madreo versus Byron, the rule is that the condonation principle applies to recall elections. In your dissenting opinion, however, you emphasize that the condonation principle applies only to regular elections. Being a senior associate justice and the ponente of Carpio Morales versus Court of Appeals, which abandoned the condonation doctrine, why were you not able to convince your fellow justices to adopt your dissenting opinion?
Well, convincing them, Your Honor, is, I mean, they have their minds on it. So I just give out my reflections and I give them a free hand to vote for or against the ponencia. But I guess one of the considerations for this is just is that recall elections would never happen again for the condonation doctrine to apply. But I still am convinced that the condonation would not be applicable to recall, because recall elections was never considered in the application of the condonation doctrine before. It was just a regular elections, and therefore there was no way we could really apply it and expand the meaning of condonation doctrine to include recall elections. They never existed in the past. There was never the prospective application of the doctrine could not have applied to something that never existed in the past.
All right, my last two questions. How old is your husband, Ricky?
My husband is already 71, Your Honor.
71. How many birthdays does the average man have?
7 average birthdays, Your Honor, meaning the lifespan.
Yes.
Well, I think he will live long enough, Your Honor, as his mother. His mother died at the age of 100, so I think he has a pretty good life. He has a pretty long life in his genes.
All right, that was my last question. Thank you, Justice, and
Thank you, Your Honor.
good luck.
Thank you, Your Honor.
Thank you, Judge Ilaw. The next to interview the candidate will be the Honorable Justice Noel Jimenez Tiham. Justice Tiham, sir.
Yes, thank you, Attorney.
Thank you, sir.
Good morning.
I
Good
was
morning,
on
Your Honor.
internet connection for a while. Good morning, Chief Justice Telly.
It's nice to hear that, Your
I have
Honor.
known you for many years. You are more than qualified to become a Chief Justice.
Thank
The
you.
purpose of the public interview is to show to the public what kind of a Chief Justice you will be. Now, Dean Serafin Cuevas from the New Era University wanted to find out whether you will be an activist, reformist Chief Justice, or you will be a moderate, conservative Chief Justice.
Your Honor, judicial activism is a judicial philosophy that holds that you can go beyond the law in order to consider some societal implications. I cannot be a judicial activist if the law is clear and the intent of the framers is clear, because I would run afoul contrary to the separation of powers that is going to be considered a judicial legislation. But if the law is vague and the intent is not clear, then I can be a judicial activist, meaning I could look at the societal implications of the ruling, the impacts on society, as well as I will exercise reason and logic and fairness in my decisions.
Now, before I go to my other questions, I'd like to read a question that was forwarded to the JPAS. The question is, are you in favor of publishing the SALN of members of the court, provided it conforms with the Data Privacy Act? That's not my question. That was a contributed question.
Well, for me, Your Honor, I have really nothing to hide. It's just that sometimes people tend to criticize or to find ways and means to really destroy the reputation of a justice. And so I think this summary of the SALN would just be enough. And if there are cases or there are complaints against the justice, then I think the complainant should really file a case in the proper forum.
Do you subscribe to the statement of former Supreme Court, retired Supreme Court Justice, now Ombudsman Martires, that to a certain extent, the SALN has been weaponized?
To a certain extent, yes, Your Honor, because sometimes a justice is a person of integrity, of competence. I mean, he has all the qualifications of a justice, but it might come to a point where the SALN can be used to destroy his reputation. And the justice will be just so busy defending himself or herself.
Talking about the SALN, after I penned the decision in Republic versus Sereno, which, by the way, you dissented from, and this allowed President Duterte to appoint 3 Chief Justices within a span of 3 years. The question is, when you are appointed as Chief Justice, will you serve out the term until you reach the age of 70? Or will you also opt for early retirement to allow the appointment of a 5th Chief Justice?
I haven't given a thought to it because I have not been appointed as yet.
Now, the other inputted questions, I don't know if this was already asked because I was out of the internet connection. The question of Justice Francis Ardilesa, was that asked of you already? Not yet?
Not yet.
Justice Ardilesa, who, by the way, is watching this public interview wanted us to ask you whether Article 8, Section 15 of the Constitution, which provides that all cases or matters filed after the effectivity of this Constitution must be decided or resolved within 24 months from date of submission to the Supreme Court, whether you consider this mandatory by way from your personal perspective, whether this is mandatory or directory. And I'd like to premise that by saying that all of the Supreme Court justices are burdened with work. Okay, but do you consider this provision mandatory or directory?
Your Honor, the court, sitting as a collective body, has already ruled in the case of, I think, 2019 case of Enables, that this provision, Section 15(1) of Article 8 of the 1987 Constitution, is directory in nature insofar as the members of the court are concerned. And the reason cited was the Supreme Court should be given ample time to deliberate on issues to ensure that the litigants' rights are protected, especially though the public interest cases. But notwithstanding this current jurisprudence, I recognize that the court should really strive very hard to find the most efficient way of disposing cases. And therefore, if appointed as Chief Justice, I will explore means and ways to really visit the internal rules, conduct a holistic study of it, streamline the court processes so that I will be able to strike a balance between the right to speedy disposition of cases and the practical logistics of the court's heavy dockets and institutional capabilities.
But corollary to that, other appellate courts and lower court judges are also bound by periods within which to decide. Should there be a uniform or a common standard of compliance and a common standard of sanction? Because I recall there was a Court of Appeals justice, I will not mention the name, who was sanctioned by the High Court for failing to decide a number of cases, admittedly, when she was still a regional trial court judge. From the public perspective, there is seemingly a different standard of compliance and sanction. Does this violate the Equal Protection Clause?
I don't think so, Your Honor. Actually, we have to also recognize that the perennial challenge of the judiciary is really how to decongest the dockets of the court. And the lower courts, even the appellate courts, for as long as there is justifiable reason for non-compliance, they could really ask extensions from the Supreme Court to extend the deadline of the resolution of their decisions. In the same manner, the Supreme Court also asked for extension. That's why I think you're very familiar with our 3 months call again, a phrase that we use in the court to extend the deadline of our decision-making process.
You have no objection to monitoring the status of pending old age cases and making it public. Is there any constraint to making it public so that the public will know?
Well, the public, of course, certainly will open the Supreme Court to criticisms. For me, I don't really see any problem because I do not have an age case since 2017. But for the other new appointees, there are age cases which were just passed on to them, and they need time to go over the records of these cases So I don't think they'll be able to comply at this time with the 2-year requirement of the Constitution if assuming that it be made mandatory. So I think we just have to give them more time, and I will see to it that these age cases will really be resolved, or there's going to be some kind of a program for this during my term.
With the advent of vaccine nationalism and the dearth of supply of vaccine, when you are appointed as Chief Justice, what brand of vaccine will you recommend for the judiciary?
Actually, I'm confused already about the details, the implications of all this vaccine. So I still have to further study the effects of each vaccine and whatever and the age, the material age for each vaccine that will be suitable for each employee.
But as a logical, a rational layperson, not as a magistrate, aside from vaccination, is there at present another cure against COVID-19? As a layperson, it seems that vaccination is the thing available, correct?
To me, I think if you already have a pneumonia flu vaccine, I think your immunity system is already going to be very strong. Because to me, the COVID-19 is somehow really related to pneumonia. But right now, I think the safety protocols would just be set in place in order to ensure the health and welfare of the employees.
Now, the palace and even the Department of Labor and Congress have stated that each citizen has a constitutional right to refuse immunization or vaccination against COVID-19. Do you subscribe to that, Your Honor?
Yes, because the right to health is a constitutional right, and I think employees should be given the right to refuse or not to refuse this vaccine, so that the vaccination should just really.
If an employee of the judiciary refuses to be immunized, inoculated, or vaccinated, will you allow that employee to go back to work if you are Chief
Yes,
Justice?
but I think I will be more strict with the safety protocols for that employee.
Notwithstanding Article 284 of the Labor Code, which says in case of serious illness or if an employee is suffering from any disease, the employer may terminate the service of an employee. Isn't it important that you also look into the health and well-being of the other employees within the judiciary?
Yes, I agree with that, but I think the right to health would still be important for this purpose.
Do you encourage judicial legislation, Your Honor?
Well, definitely not, because it will breach the principle of the separation of powers. And I think Congress and the executive will be mad with us doing that.
Judicial legislation violates the Constitution and the principle of separation of powers.
Yes.
Do you agree with me that judicial legislation may amount to culpable violation of the Constitution and therefore an impeachable offense?
Well, in a sense, yes.
Because what is more clear is to violate the principle of separation of powers. So how will, as Chief Justice, how will you discourage judicial legislation?
I will not only discourage it, I will prevent it from happening.
What about the sub judice rule, Your Honor? How will you balance it vis-a-vis the right of the public to know? the freedom of expression, the freedom of the press to make comment on issues before the court. Because at any rate, judges, magistrates are trained not to be influenced by external forces.
The sub judice rule is limited in its application. It will only apply if it tends to influence the judge or the justices in rendering its decision. So if it doesn't go to that extent, then I think you can really talk about the case, and that's not going to violate that's going to be an expression of that's going to be in pursuit of your freedom of expression.
Now let's talk about a decided case already concluded, the Marcos versus Robredo Pet case. Without going into the merits of the decision, because the court has already spoken, on hindsight, and in your opinion, it took the court 5 years to make a declaration that the petitioner failed to produce evidence of electoral fraud. What could have been done differently, on hindsight, only for purposes of academic discussion, to fast track the resolution of that electoral protest?
No, the electoral protest contains volumes of records, and I cannot blame the ponente for not deciding it as quickly as possible. You may recall that this used to be handled by Justice Kadiwa and merely passed on to Justice Leonen. And when it was passed on, he has to review the voluminous records of the case again. And he has to be very careful because this is a political, somehow it has a political color. And he was very careful in deciding this case. But you are asking me if I were the ponente, how would I decide it quickly? Well,
without casting aspersion on the opponent, what could have been done differently? I mean,
yeah, it could have been done differently.
Finding out that there's no
evidence. It really depends. It really depends on how.
Look for the evidence. Isn't it that the petitioner is supposed to produce the evidence? And if there is no evidence, then the court should have dismissed it outrightly.
Yes, and in fact, that was what Justice Leonen did. Insofar as the third cause of action is concerned, he went through every piece of evidence without saying that we should reopen the third cause of action. He made sure that if the case was reopened, he would come out with the same conclusion. That's why it took him a while to resolve the case, because he has to go through every piece of evidence that were presented.
Now, when you decide policy cases where the executive branch has the responsibility of protecting national security, as Chief Justice, how should the Supreme Court balance the interests of the executive, expertise in national security matters, vis-a-vis the judiciary, constitutional duty to enforce the Constitution and prevent abuse of power?
Insofar as policy matters are concerned, there is somehow a deference to the President's executive power, but we can also check that if the exercise of this power is within the bounds of truth and reason.
You have heard about the doctrine of purposeful hesitation in deciding the constitutionality of the law. A law is passed by Congress, and there are lawyers in Congress. They're supposed to be conversant of the Constitution. Should the judiciary right away look into the language of the law, whether the law violates the Constitution, even in the absence of an actual controversy?
Are you saying that even before it is
That's
passed?
a hypothetical question. That is not an actual, it does not pertain to an actual case.
Meaning before it is passed, we should look into it already, or
No, after Congress has
after it is passed.
petitioners went to the Supreme Court questioning the constitutionality of that law because the language of the law violates the Constitution. Should the court adopt the doctrine of purposeful hesitation, considering that the law is presumed to be valid?
We do not handle a case when it is not right, when there is no actual controversy. And therefore, when a law is passed and there's no case before us, then we do not give advisory opinions on this.
My last question is, the court in Geo Summer has clearly delineated guidelines where litigants and lawyers can go directly or make direct relief and seek direct resort to the court. Do you adhere to the doctrine of justiciability, or are you willing to accommodate in certain cases the doctrine of capable of repetition, evading judicial review? In other words, even if a case has already become mooted, if it is capable of repetition, evading judicial review as Chief Justice, will you direct the bank
Yes,
to consider it?
yes, I think we should do that so that we can settle once and for all issues that are really important and that will guide the bench and the bar and the public of this of the rulings of the court on this. So it will not come up again.
Similar to an advisory opinion? Is that not similar to an advisory opinion, since there is no actual controversy anymore, and yet you would that
we have
doctrine
crafted exceptions, Your Honor, and this is one of the exceptions to taking cognizance of a case that has been mooted.
All right. Thank you very much. I have read the long-term and short-term plan. I think we will flash it during the break, and this will be shared with the media and to the public. Okay. Thank you very much, Your Honor, and good luck.
Thank you.
Thank you, Justice Tiham. The next to interview the candidate will be the Honorable Justice Jose Catral Mendoza. Justice Mendoza, sir.
Yes, good morning, Justice.
Good morning. Good morning.
This is your second time. I forgot what I asked you before. I think I did not ask you questions before, right? Did I questions
I
before?
think you did, Your Honor,
What did I cover?
About my cases, my judicial philosophy.
Okay, I think. Well, the questions or the areas I want to cover were already covered by my colleagues, but I want to ask some questions or follow-up questions with respect to your previous responses and what you have written in your short and long-term plans. But first, I would like to ask you, what is your understanding or perception of the position you have applied for?
Well, the
What do you
position
think of its power and its limitation?
well, to me, the office of the position of the Chief Justice is not just a pinnacle of the professional career, but rather it is one once in a lifetime opportunity to institute changes in the judiciary. It is a position that requires meaningful collaboration with all the stakeholders. It is not a position of superiority, but rather one of a position that involves consultations with the other stakeholders of the court. The problems of the court are deeply rooted and persisting, and therefore I believe that it cannot just be solved by one person, but you need the involvement of many on this in pursuing the plans and programs of the court.
Especially the members of the Supreme Court. You will
Yes,
be their leader. You will be the primus inter pares. What
Yes,
are the limitations of that position? You have been in the Supreme Court for 9 years. You should know
for 9.5
them by now.
years.
Yeah, 9.5 years.
I think all the members of the court should be open-minded, just as I will be open-minded to them. And there will be collegiality, respect, and support for all the programs that they would propose, as well as I will encourage them to actively involve themselves in the programs which I will pursue.
Yes, sir. I'm a member of the JBC representing the retired justices of the Supreme Court, most of whom sent questions, and I will propound some of them. But some of them were already covered, like the one asked by Justice Hardelesa. I just have a follow-up point there. The complaints of trial court judges is that the Supreme Court has interpreted the constitutional provision on the 240 days or the 2-year period as directly. But in their case, seems it is mandatory. They ask, why should trial be judges, or why they should be treated differently? Can you answer that? I know your answer to that, but I want you to satisfy them and the public.
The lower court judges are heavily laden with so much cases, and therefore I don't think they could really dispose of their cases within the time frame, except of course for some. But the court is not strict with them in the sense that if there are justifiable reasons why they couldn't comply with a period of 90 days, then they could ask for exemptions. And this policy holds true insofar as the appellate courts are concerned, and also insofar as the Supreme Court is concerned. We have any Supreme Court justice can always ask for extensions in the deadline within which
in the Supreme Court it's called 3 months, right? The maximum. Call again 3 months. Call again.
Yes.
That's
yes,
the maximum.
Yes.
What is
Yes,
the
Your
maximum?
Honor.
Do you think? Can you provide or allow, which you can allow to trial court judges, MTC level and RTC level, because you have been a first level court judge and then a second level court judge, and even in the Court of Appeals?
We have not really set a maximum period for judges to ask for extensions. I mean, they could keep on asking for as long as there are justifiable reasons for the extension.
Okay, it will be on a first case-to-case basis.
Yes, Your Honor.
So, but you will maintain that with respect to the lower court judges and justices, the period is mandatory.
Well, effectively, it becomes directory already in
Directory
the sense
also.
that they can ask for extensions. Although if they do not present a justifiable reason for it, they may get sanctioned.
I see. You have been with the Court of Appeals and you've been with the Supreme Court. Are you aware of the initiatory load of a Court of Appeals justice? What is the rule there, if you remember?
In my case, I think I had about 600 cases in the Court of Appeals.
Now, in the justices in general, a new justice entering, what is the initial?
In the Court of Appeals?
Yes.
I do not know now, Justice, because there are now 69 justices now, but I think the initial case load would be about 300 to 400.
Yes, like before, 300, yes. Oh.
Unlike before when it was higher.
Now, you've been promoted to the Supreme Court. What is the difference regarding the initial caseload?
It's much higher. And the cases that come to us before the Supreme Court are more difficult. The issues are more complex.
Yes, but my question was on the initial caseload of a justice.
It's about 650 is the average.
Yes, average. If the justice you replace had lower load,
then there will be an unloading of cases.
Unloading. Yes. The problem is if you inherited, for example, 1,000, like Chief Justice Persamin, like one of and the justice who replaced Justice Persamin, they have a high caseload, but they just inherited it. What do you intend to do about them? The initial caseload, that is really a problem in the Supreme Court. Well, the others are happy, they just received 650, but the others are complaining because they have received more than 1,000. What are your plans, or what are you going to do about them? That is a perennial problem. Even I even asked Chief Justice Persamin about that when he was interviewed, because he was affected, but he declined to answer that because it might benefit him or affect him.
I plan to set up a pool of
self-serving.
I plan to set up a pool of lawyers to assist in the resolution of the age cases. So probably I can give priority, or I can give more concessions to the ones with higher dockets.
Yes. What we did before in this Court of Appeals was to ask the senior justices with few caseloads to help in drafting the decisions and resolutions. And in the Supreme Court, during the time of Justice Persamin, more lawyers were assigned to him from the Court of Attorneys. But he said he called it's really an imbudo, because ikaw rin ang gagawa eh. Ikaw rin ang mag-decide.
Your Honor.
That's his problem before.
During the time of, yes, Your Honor, during the time of Sereno, there was a program, a zero backlog project, and there was one lawyer added to each office, and we created a pool for it, except that the justices found it hard to adapt to the writing style of the justice, and so they were not amenable to that kind of project.
Anyway, you mentioned that you will be creating a committee to study that.
Yes, Your Honor. I will look into that, Your Honor.
Yes. If you would be appointed as the Chief Justice, you will be the chairman or chairperson of the Judicial and Bar Council. Now, recently the Supreme Court and Bank issued a resolution expressing the sense of the court with respect to the requirements of the EBC. in response, we eliminated so many requirements already, and we just left those which need to be updated. Have you read the resolution of the JBC and Bank addressing
Honor.
sense of the? Oh,
Yes, Your Honor.
what is your comment on that? You will be appointed. You will be our chairperson, and I just want to say that before we decided that, we consulted so many interested parties, even the media, in the public, and they want that the candidates be interviewed. And about the other requirements?
I agree that we can dispense with some of the requirements of the JBC. And in fact, that is one of my projects, to digitize the records of the JBC so that it will not be asking repetitive requirements from applicants. Now, insofar as the interview...
We have those one-time requirements already. We have listed them, so we will not ask them anymore.
Insofar as the interview request of the justices to be exempted, then I'd like to hear the panel on that before I give out a decision.
Yes. How about the other one-time requirements, or the other requirements which the JBC did not waive? What is your view on those?
I agree with all those requirements, Your Honor.
I see. I was looking at your plans. You mentioned for your short-term plans is to study, expand the scope, and increase the claim thresholds under the rules on summary procedure and small claims. Can the Supreme Court do that?
Yes, Your Honor. This is going to be part of the duty of the Supreme Court to promulgate rules of procedure for as long
But
as
is it not jurisdiction it's conferred by law?
Yes, Your Honor. For as long as the jurisdiction is not affected, then the rules of procedure can go on.
So you have to ask Congress to increase the threshold, for example.
No, Your Honor. When I say increasing the claim threshold, I am referring to whether or not these rules can be expanded to apply to the regional trial courts.
I see. Okay.
The application of the rules, it can be applied to the regional trial courts, Your Honor.
With respect to the lower courts, there has been a perennial problem by trial courts that they are stuck with legal researchers who really are inefficient and incompetent. And if they do not pass the bar, they're stuck with them. And if they pass the bar, they leave the justices. Their proposal is that they be considered only coterminous, but prospective. But the rule should be made prospective. What can you say of this?
I think there are some really employees, Your Honor, that should be considered coterminous with a judge. I've been in the lower courts way back, and I know the problems of the judges now, that there are some clerks of courts and legal researchers, and the clerks of courts and the legal researchers who are not so competent or do not come up with their standard. So I think it's better that for newly created courts, the judges will be tasked to hire the clerks of court and the legal researchers.
I see. I am running out of time. Some of the justices submitted questions for us to us. For example, Justice Reyes, Boji Reyes, asked about the expedition of the trial, was asking about the how the disposition of the cases can be speeded up. Now, you earlier stated that with respect to those, you did not mention the word improvident plea, but were you referring to that when you were asked by Judge Ilaw, improvident
Yes.
plea?
Yes, Your Honor. It's an
Was an
improvident
improvident
plea of guilt. Yes.
Oh, are there parameters which you can suggest so that improvident pleas can be avoided?
Your Honor, the improvident pleas can be handled properly by the judge for as long as the judge explains very well the consequences of that plea. So I think the judge should really have more searching questions to the accused to be able to determine whether or not this improvident plea is valid.
Also, the Chief Justice De Castro covered the Enterprise Information System plan, which you mentioned in your plan also. For the benefit of the public, viewing public, can you inform them of what this EISP means and what is your plan for its improvement?
Your Honor, the Enterprise Information System was already approved in 2014. And that's why we had this e-courts 1, which were put up in pilot courts. I think there were about 12 pilot courts put up in Metro Manila and some in the provinces. And there were projects. This is the umbrella computerization program of the court, and it covered really everything: the case administration system of the Supreme Court, the lawyer information system, the PhilJA e-learning management system, the hearing management system. But unfortunately, there were some kinks in it. It did not work well because there were some security features that became the problem. So they were stopped. It was funded by the Abaroli before, but until 2019 when the GoJust took over it. And there was a review by the GoJust, which is our funder, and they found out that there were really some defects in the system. So this is what we are going to pursue again. We will try to fully execute this Enterprise Information Systems plan, either by getting another software or asking some technological companies to give their comments on what we have purchased already before. So this is going to really fully automize the court, Your Honor.
Okay.
It's just unfortunate that it did not work well.
Okay. Thank you. I'm running out of time. This is from Justice Brion. What is your most significant ponencia, and what is its contribution to the country, to the Supreme Court, and judiciary in general?
I have two significant ponencias, Your Honor, and these are the Priority Development Assistance Fund, its abolition, and also the condonation doctrine, which was also abolished. I find this very significant because they change the landscape of jurisprudence towards strengthening the court's stance on public accountability.
Do I still have time? I think in the case of Pimentel versus Levy, it is not yet final.
Yes, Your Honor.
Yes, and you have a separate opinion on it. Can you explain your separate opinion?
Your Honor, I am for the abolition of the PhilSat exam because when LEB does that, it practically does not regulate the institutions of learning anymore, but exercises control over it in the sense that if you do not pass the PhilSat exam, you cannot be admitted to the law school, and it violates, therefore, the academic freedom of the schools of this.
I think all of you agreed on that. How about placing there is a bill now pending in Congress suggesting that it be placed under the Supreme Court. What is your view on that?
Which one, Your Honor?
The LEB, because the LEB is now under the CHED, right?
Yes,
so
Your Honor.
the proposal that it be placed under the Supreme Court, because after all, under the Constitution, it is the Supreme Court which has jurisdiction over the admission to the bar.
Your Honor, can I refuse to answer that because the law might come to us, and
I see.
I do not want.
No, there is to be no law. It's just a bill. So I'm asking
yes,
you.
It's a bill, but it might come
opinion
before us. The constitutional that law might come before us, and I might be preempting my answer, and I do not want to be forced to inhibit later on.
Okay. I can understand. May oras pa ba ako? Who is monitoring? This is from walang sagot eh. This is from Chief Justice Davide. What are your plans regarding halls of justices in the country? Because there are so many judges who have no courts. For example, in Dasmariñas, there are 3 judges sharing only 1 court. What are your plans for those problems?
I have to identify the problems first, Your Honor. Which courts or which judges do not have any courts or any infrastructure. But I will have to identify first the deficiencies in the court infrastructure before I'm able to really solve their problem. But there are infrastructure. There are lots which are being donated already by private individuals, and we have funding for all this infrastructure already. So it's more of an identification of problems before we're able to solve these needs.
Thank you very much, Justice. I have no more time. I have plenty of questions, but I have no more time.
Thank you, Your Honor.
Best of luck.
Thank you, Your Honor.
Okay, Attorney Aricheta.
Thank you, Justice Mendoza. Thank you, sir.
Okay.
The next to interview the candidate is the Honorable Congressman, Justice Vicente Veloso III. Justice Veloso, sir.
Good morning. Good morning, Justice Telly.
Good morning, Justice Congressman.
I recall that when we were at the Court of Appeals, we had this competition on zero backlog. Do you recall that, Justice Telly?
Yes, Your Honor.
Okay. I'll take off from this query of retired Justice Ardelesa. Article 8, Section 15. I'll start with Section 16. I will read it, so there will be no debate of this. It says in Section 16, all Section 16, Article 3 of the Bill of Rights says, all persons shall have the right to speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. And Article 8 reinforces this, and I will read. Section 15. All cases or matters filed after the effectivity of this Constitution must be decided or resolved within 24 months from date of submission for the Supreme Court, and unless reduced by the Supreme Court, 12 months for all lower collegiate courts and 3 months for all lower courts. This Section 15, Paragraph 1, has a defining provision. Despite the expiration of the applicable mandatory period, the court, without prejudice to such responsibilities as may have been incurred in consequence thereof, shall decide or resolve the case or matters submitted thereto for determination without further delay. My first question, Justice Telly, is I heard that a lot of judges of the lower court, and in fact, I also know of a justice of the Court of Appeals who was disciplined or who were disciplined because of delay in the disposition cases. Do you recall that?
Yes, Your Honor.
Therefore, when we speak of the right to speedy disposition of cases, particularly Section 15, this matter of deciding cases within 24 months for the Supreme Court is not only mandatory, it is also punitive. And I will read paragraph 4, it says Section 15 of Article 8, despite the expiration of the applicable mandatory period, the court, without prejudice to such responsibility as may have been incurred in consequence thereof, shall decide or resolve the case or matters submitted thereto for determination without further delay. So if a judge in the RTC or if a justice of the Court of Appeals could be readily disciplined by the Supreme Court for the delay in the disposition of cases, kindly tell this representation, Justice Telly, why the Supreme Court should be exempted from such mandatory and punitive action.
Your Honor, the reasons why these judges were disciplined was because they did not ask for an extension and they could not give any explanation for the delay or for the non-compliance with the period within which to decide. Had they asked extension, the court granted it, concealed the fact that there was delay in the disposition of the cases. That's why they were sanctioned. Now, everyone can ask for exemption, and there is no limit to that exemption for as long as you are for as long as you ask for it and you're honest to you're honest to admit that you have not complied with the mandatory periods resolving cases. In the court, we also asked for the extension. Extensions have been granted by the court sitting as a collective body.
Justice Telly, Section 15, Article 8 provides in Section 15, Paragraph 2 that a case or matter shall be deemed submitted for decision or resolution upon the filing of the last pleading, brief, or memorandum required by the rules of court or by the court itself. So if in a situation there has been no extension, as you earlier explained, granted by the court, and the case has already been deemed submitted for resolution, what further explanation should the Supreme Court require from a trial court judge or from a collegiate court justice, or even for that matter, from the Supreme Court justice who is guilty of delay in the disposition of cases?
For lower courts, they cannot be held guilty of delay if they ask for extension and cite justifiable reasons like clogged dockets of the court or illness or anything that the court would find as reasonable. Now, in the Supreme Court, we asked for extension to call the case again, and the court grants the extension. And I would say that that is enough already for the court to effectively extend the expiration of the period. Of course, Your Honor, I understand the right of the people to speedy disposition of justice. And therefore, when I become one, I will try to balance this. I will create a reasonable balance between this right and the heavy dockets of the court.
So let me close that window, Justice Telly, by just saying that if submission of a case for a disposition is extended by the Supreme Court, that is already an exception to the mandatory character of Section 15. And if there is no extension made by the Supreme Court, then the Supreme Court justice handling that case can be disciplined under section or by force of Section 15, Article 8. Is that correct, Justice Daly?
That is the inference. That is the inference, Your Honor. But I will look into that, Your Honor, and work on it if I become chief.
Okay. You mentioned in your letter dated March 10, 2021, that you are talking about special projects, initiatives for case decongestion. And you can increase the competency of courts by providing judges with a complete and updated
We are also implementing the Family Courts Act, And once we have implemented this, there will be 183 statutory family court judges. And this will relieve the designated family courts of their family court assignments for them, allowing them to focus on the handling of their own cases.
My last question is regard. A lot of questions have already been asked of you. So you will be retiring a year from now. Is that correct?
Yes, sure.
And you have been known to be a very competent justice at the Court of Appeals
Thank you, Your Honor.
with a zero backlog. How many cases do you still have that are pending before the Supreme Court?
Right now, I only have 67 judicial cases, Your Honor, and I am unloading. I'm entitled to unload 27 cases, so that leaves me 40 cases to decide.
That would be all, Mr. Chair.
Thank you, Your Honor.
Thank you.
Thank you, Congressman Justice Veloso. Tony Lea, close na. Wala eh. That concludes the public panel interview of Madam Justice Perlas Bernabe. Good luck, ma'am.
Thank you. Thank you very much.
Your Honors, shall we suspend the proceedings for this afternoon and continue this afternoon? Secretary of Justice, will you take the interview also?
No, our time is up already. We'll resume with the permission of the chairman this afternoon.
Thank you, Justice. Thank you, Secretary. So that concludes the public panel interview for this morning. We will continue at 1 o'clock this afternoon. Thank you.
4, 3, 2, 1.
Your Honors, good afternoon. This is a continuation of the public panel interview by the Judicial and Bar Council of candidates for the position of Chief Justice of the Philippines, Vice the Honorable Diosdado M. Peralta. The members of the Judicial and Bar Council are the following: the Honorable Chief Justice Diosdado M. Peralta, ex officio chairperson representing the judiciary. The Honorable Secretary of Justice Minardo Guevara, ex officio member representing the Executive Department. The Honorable Congressman Justice Vicente Veloso III, ex officio member representing the Legislative Department. The Honorable Justice Jose Catral Mendoza, chairperson of the JBC Executive Committee and regular member representing the retired members of the Supreme Court. The Honorable Judge Toribio Ilaw Jr., regular member representing the private sector. The Honorable Justice Noel Jimenez Tiham, regular member representing the Academe. And the Honorable Judge Franklin J. de Monteverde, regular member representing the Integrated Bar of the Philippines. The candidates for interview this afternoon, Your Honors, are Associate Justice Alexander Gahon Gismondo and Associate Justice Ramon Paul Layugan Hernando. Your Honors, the first for interview will be Justice Alexander Gismondo. Mr. Justice Gismondo, sir, can I request you to please rise and raise your right hand so that I can administer the oath? Justice, do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial and Bar Council?
Yes, I do.
So help you God. Thank you, Justice. The first to interview the candidates is the Honorable Chief Justice Diosdado M. Peralta. Chief.
Well, thank you. Thank you, Ed. Good afternoon, Justice Alex.
Good afternoon, Chief.
Yeah. Justice Alex has been very active in the rulemaking duty of the Supreme Court. In fact, in some of the committees that I headed, Justice Alex is in most cases, in most committees, Justice Alex is my vice chairperson. But because I'm retiring on March 27, and there are still rules to be tackled, may I know if from Justice Alex, if he will continue the programs that I have started insofar as the drafting of rules are concerned?
Mr. Chief Justice, I assure you that whatever pending revisions, I will continue it. In fact, we're still working on the rules on criminal procedure, and hopefully all other pending rules that needs to be amended will be completed with a specific time frame, perhaps in 2 years.
Yeah, I hope
I will continue whatever you have started.
I hope that you will be able to finish the amendments on the rules on criminal procedure, because we are already halfway through. Now, I take advantage of the presence of Congressman Veloso. You remember that last year, when I assumed the office of the Chief Justice, we proposed to Congress for the amendment of the jurisdiction of the first level courts on two specific provisions of the jurisdiction on insofar as first level courts is concerned. The main purpose then was to unburden the second level courts of so many cases, because most of the cases that are being handled by the second level courts are drug cases. So we propose to Congress for the amendment of the jurisdiction of the first level courts as follows. Number one, to increase the jurisdictional amount of money claims from 400,000 pesos to 2 million pesos in Metro Manila area or in metropolitan trial courts, and 300,000 pesos, the maximum amount or the jurisdiction amount of first level courts outside of Metro Manila, from 300,000 to 2 million pesos. And the other proposal is to increase the assessed value of real properties from 20,000 pesos assessed value to 200,000 assessed value. But if these proposals will become a law, then there will be some cases, civil cases, that will be brought to the first level courts. In yesterday's session of the JSCC, the Justice, this Justice Zone Committee, or the JSCC for that, I'm sorry, the JSCC, where I and the Secretary of Justice, Bernardo Guevara, and the officer in charge, Secretary Florese, of the DILG, we received a good report from our development partners in the person of Attorney Hector Soliman that the special rules on small claims, the special laws on continuous, or the special guidelines in the trial of criminal cases had reduced the dockets of the first level and the second level courts by 82%. In other words, these guidelines have been very effective tools in reducing the dockets of our courts. Now, I was expecting that the two proposals would become a law before I retire. The reason why I am very particular on this, and I hope you will agree with me, that if these rules will be approved, you will, and you are now the Chief Justice, will you recommend the increase of this threshold amount in small claims, if it is only 400,000 pesos, to as high as 1 million pesos? Because once the jurisdictional amount is increased to 2 million pesos, then we can also increase this threshold amount of 400,000 pesos to 1 million pesos to accommodate more small claims cases. What is your idea on this, Justice Alex?
Your Honors, I will have no objection if the threshold amount for purposes of cases covered by the rules on small claims be increased to 1 million pesos. That is a very realistic figure now, considering the inflation that had taken place from the time that the original rules on small claims were promulgated. It's a very realistic approach because most claims now involve practically millions of pesos as minimum because of the nature of the transactions of people now.
Yeah.
So
the other thing that I would like to ask from you, your opinion on this. Can we come up with a revision of the rules on small claims, no? Or even other cases emanating from the first level courts, so that cases decided by the first level courts, if sustained by the regional trial court, insofar as the finding of facts by the first level courts is concerned, in other words, if the second level court sustained in toto the finding of facts of the first level court, and we expect a lot of cases that will go to the first level court because of the amendment of the jurisdiction of the first level court, can we put or indicate or make a rule that if the finding of facts of the first level courts are sustained by the second level courts, the remedy of the losing party in the RTC, in the RCC will now be only Rule 65, Rule 65, considering that the finding of facts of the RCC are now considered final. So in other words, you can no longer appeal because the finding of facts of the RTC is already final, and therefore the remedy is Rule 65. I ask this question because if the remedy of the losing party is Rule 65, if going to the Court of Appeals, then there is no other remedy of the losing party in the Court of Appeals except Rule 45, which is a discretionary appeal which can be dismissed by the Supreme Court outright. That will also solve the problem of so many cases filed before the Supreme Court. Is that possible, Justice Alex?
I think that to a certain extent, that will be an effective filtering mechanism,
Yeah.
especially cases that should not reach the Supreme Court.
Yeah.
Considering that the appeal from the regional trial court to the Court of Appeals under the present rule is an ordinary appeal, I would rather petition for review because the decision of the RTC was rendered in its appellate jurisdiction. I would say that 65 would be the appropriate remedy from the adverse ruling of the RTC. Because the first appeal can be considered as a matter of right. A party is entitled as a rule, as a matter of right, one stage of appeal. And the second appeal will be in the nature of a discretionary appeal.
Yeah.
So I would agree to that proposition.
Yeah. So we'll be resolving a lot of cases in the Supreme Court if the Board of Appeal is Rule 45 being a discretionary appeal.
That's correct, Your Honor.
Can I get your commitment that if the expanded jurisdiction becomes a law, you are not the Chief Justice, you will constitute a committee that will amend the existing rules so that we can incorporate the proposal and your opinion into the rules so that it can be implemented as soon as possible?
Yes, Your Honor. Of course, without prejudice of inviting you to become a consultant of that committee that may be created purposely to revise the rules.
Yeah. The other one that I would like to ask from you is that you were talking about you said that we are already halfway through with the rules on criminal procedure. Now there is a proposal to change or to amend the threshold of evidence in the filing of cases before the courts, because under the present provision, the provision of the rules provides that there must be a probable cause in the filing of the information before the court. And in our discussion, I propose that this provision might have been one of the causes why there are so many cases filed before the RTC, because probable cause evidence is not as strict as prima facie evidence. So in some cases, fiscals will be filing cases, even if there is a valid defense in a preliminary investigation. In most of their resolutions, they will say that insofar as defense is concerned, that is within the province of the court, and therefore filed information because there is a probable cause to file the information. Now, by recommending the threshold of evidence from probable cause to prima facie evidence, in your opinion, do you think that this will be one way of declogging the dockets of our courts because of this probable cause requirement in the filing of the information? What do you say, Justice Alex?
Actually, even before, I think in the 1964 rules on criminal procedure, the quantum of proof required for purposes of filing an information in a criminal case in a court is already prima facie. But along the way in the revision, succeeding revisions, it was downgraded to probable cause. And therefore, the strictness before a case can be filed in a court apparently disappeared, such that filing of criminal cases based on probable cause has become more, I would not say easier, but the examination to determine probable cause has become quite lax in a sense. Going back to prima facie case would require the prosecutors to assiduously study the case before deciding to file a criminal case. I would suggest that I would agree that prima facie being the threshold for purposes of filing a criminal action would be a better move at this point in time.
Now, without prejudging any case, no, I will not. My next question has something to do with search warrants. No, I do not want to prejudge any case. This is merely an academic discussion. When a judge issues a search warrant and therefore finds a probable cause to issue a search warrant, does he rely on the existence of a probable cause from the affidavit of the applicant or the affidavit attached to the application or a search warrant, or from the questions that he or she propounded during the searching questions, these proceedings as required under the Constitution?
Honor, the Constitution and the rules of court are very clear. The Constitution says that no search warrant or a warrant of arrest shall be issued except upon probable cause determined by a judge after conducting searching inquiry, meaning asking questions from the complainant and the witnesses he may produce. The judge, in determining probable cause for purposes of issuing a search warrant, will have to resolve it on the basis of his own searching inquiry. He cannot solely rely on the affidavits of the complainant and the witnesses he may produce, because that will be in violation of the Constitution, as well as the rules on criminal procedure. The rules are clear. The judge must conduct a personal searching inquiry, and therefore, if he decides to issue a search warrant, his primary basis should be his own determination based on his examination of the applicant as well as his witnesses.
Okay.
He cannot totally rely on the affidavits of the complainant and that of his witnesses. That will be in violation of the requirements under the Constitution and the rules on criminal procedure.
Now, there are of course we know that in resolving a motion to quash, or where the motion to quash of the search warrant, where should it be filed? The rules are very clear. No, a motion to quash should be filed before the court that issued the search warrant, as long as there is yet criminal information filed. That's very clear. But if the criminal information is already filed, then the motion to quash should be filed before the court where the criminal case is filed.
That's correct, Your Honor.
Is it correct for a judge to resolve a motion to quash, where the information is filed, without consolidating the records of the issuance of the warrant of arrest with the criminal case?
Your Honor, I don't think that's a proper way to resolve a motion to pass a search warrant issued by a court other than the court where the information was filed. First, the judge before whom the case was filed should secure the records in the other court that issued the search warrant. Because how can you possibly, what will be your basis to quash the search warrant unless you have seen the proceedings or the records of the proceedings in the other court? That
Yeah.
will not be a judicious way of quashing a search warrant. He must
Yeah.
have in his possession the records of the court that issued the search warrant.
Yeah.
Because he will practically, in that instance, the judge before whom the case was filed and before whom the motion to quash was filed will be resolving the motion to quash purely on the basis of the assertions of the movement. And that will not be fair, I think, Your Honor.
Yeah, I'm asking all these questions. I started with the question about rules, and I am ending up my questions also on rules because you agree with me that one way of reforming the courts or one way of hastening the resolution of cases, the remedy is to amend the rules or introduce new rules, introduce innovations in order or simplify the rules in order to hasten the resolution of cases. Do you agree with me, Justice Alex?
Yes, Your Honor, I agree.
Yeah. Now, I have a follow-up question on that now. Remember when we were drafting the rules on civil procedure, and you were my vice chairperson, I was the chairperson, the first thing that I told the members that you will be surprised, I said, that in the rules in civil procedure, you do not find any reglementary periods to be followed by judges and even lawyers. You remember what I said to you?
Yes,
to the
Your
members of the committee, and we have to resolve that issue. Number two, I also said that one way of determining the efficiency of the judge is to whether or not there are periods to follow. There are reglementary periods to follow because it's only in that way that we can determine how fast the judge is working on a case. I think that was also what I reminded the members of the committee when we started revising the rules on civil procedure. Do you get my point, Justice Alex? You remember? Yeah.
Yes, Chief.
Yeah. And I also told the members that what we've been doing in the Supreme Court in determining the efficiency of judges was to determine how many cases had he resolved within a certain period of time, but we do not know how long he resolve those cases, right?
Yes.
Yes. Okay.
Yes, Chief.
And also, I reminded also that in the guidelines of criminal cases, we have provided specific periods or reglementary periods for each of the procedures. There is a period for arraignment, there is a period of pre-trial, there's a period of trial, there's a period of resolving motions, there's a period of resolving demurrer, and so on, and even decisions. No. I asked this question, I want to remind you of this question, because as I said a while ago, I think Justice Secretary Manuel Guevara will confirm this, that there was a report, as I said, of Attorney Hector Suleiman of the impact of the continuous trial in criminal cases. And I can vividly remember that the dockets of the court as far as criminal cases are concerned reduced by 82%. Now my question now is this, no? Can we adopt likewise reglementary periods to be followed by the appellate justices in the Court of Appeals, Sandigan Bayan, and also Court of Tax Appeals, so that probably we can also achieve the success, if we call it success, of the continuous trial in criminal cases and also continuous trial in civil cases by providing reglementary periods to be followed. Justice Alex?
Your Honor, let's look at the situations in the different courts. In the Court of Appeals, practically the jurisdiction is with respect to two things. ordinary appeal, or petition for review.
Yeah.
And therefore, I think they have adopted the system by which they have they want to expedite cases, the zero backlog. But for purposes of processing an appeal, the period, I think, would not necessarily be fixed anymore, because the rule is that once the appropriate pleadings, meaning the appellant's brief and the appellee's brief are in, it should be the natural course that the Court of Appeals, to whom the case, the justice to whom it's assigned, should resolve the case or on appeal. So therefore, it is incumbent upon him or to the justice in charge to make sure that when the pleadings are in, he should be able to decide the case immediately. There is no harm if we fix a period within which an appeal, the case that is appealed to the Court of Appeals should be decided.
Of course, in the Sandigan Bayan, because
Bayan will be a different situation.
that's why. Yes, that's correct. Because in the Sandigan Bayan, they have original jurisdiction and appellate jurisdiction.
That's correct, Your Honor.
So for original jurisdiction, probably they have to follow the periods provided for in the guidelines in the continuous trial in criminal cases. Probably they can do that.
Yes, Your Honor, perhaps they can do that. But another point to consider is that the cases at the Sandigan Bayan would have different parameters, in a sense that in some cases there is only one accused, in some cases there are several accused. So perhaps in setting the time frame within which a particular action must be done by the Sandigan Bayan, we have to also take into account the complexity of the case being presented. So perhaps if we say that there is only one accused, the period of processing should be as follows. But with respect to complicated cases, because of the number of cases, number of the parties involved, perhaps another period may be fixed in the rules. So we have to address also the complexities of the case in the Sandigan Bayan.
Yeah. Now, what about in the Supreme Court? Can we adopt reglementary periods? Of course, the Constitution says that within 2 years or 24 months, we have to resolve the cases from the time the cases are submitted for decision. I think that's the one that we are following. But of course, with just too many cases that we are resolving, sometimes we go beyond the 2-year period. So that is the only reglementary period that is required of us in the Supreme Court.
Your Honor.
Yeah.
The Constitution says that the cases at the Supreme Court should be decided within 24 months.
Yeah.
There is a second provision following that if a case cannot be decided within the period, the Chief Justice must issue a certification, which must be contained in the record, stating the reason why the case was not decided within the 24-month period provided in the Constitution, and parties must be notified of that action. Present jurisprudence says that the period provided for in the Constitution as far as the Supreme Court is concerned is persuasive. The justices of the Supreme Court should be given some flexibility. I agree with that. However, there is a substantial reason why Supreme Court is given 24 months. Lower courts are given, I think,
90 days. 90 days.
90 days to decide. And this is the distinction. In trial courts, there are two contending parties, the plaintiff and the defendant. A case before a trial court focuses on the issues between the contending parties. Cases are looked from a myopic view concerning the parochial interest of the parties before the trial. That is not the case in the Supreme Court, Your Honor. The decisions or the proceedings of the Supreme Court must be viewed from the myopic view of the trial court to a broader canvas. Why? The decision of the Supreme Court establishes precedents. It established doctrines. The ripple effect of the Supreme Court decision is not really confined only to the parties that is before it, Your Honor. The decision of the Supreme Court is such that it creates as a precedent, as I said earlier, but the impact of the decision is not solely for the benefit of the parties before it. The doctrine laid by the Supreme Court is so encompassing that it practically determines the outcomes of future cases. And therefore, it requires a lot of deliberation. That's why 15 members of the court are involved with different views or different assessment of a case. And until such time that a collective decision is reached, that is the only parties litigant in the trial court is substantially different Supreme Court. The doctrinal value of the decision rendered by the Supreme Court will guide the trial courts on how to decide cases similar to that previously decided by the Supreme Court. And that will provide judicial stability. That is the marked distinction, Your Honor, why flexibility should be accommodated to the Supreme Court.
But if we
different thinking.
Yeah, but if we reduce the number of cases going to the Supreme Court, that will be a good help to the Supreme Court.
Your Honor, may I say that by the incantation of transcendental importance or of paramount public interest, as pointed out in the decision, the Supreme Court must be very strict in entertaining petitions under Rule 45. Absent factual bearings from which the court can decide the case, the court should dismiss these petitions. In connection with that, additional step.
Room.
May I continue, Your Honor?
Yeah, let me see. Let me see if it's already okay. Okay,
Yeah,
it's okay.
Okay na.
Okay na. Okay.
May I continue, Your Honor?
Yeah.
Those who have been to the Supreme Court, we have adopted a method of...
Okay, go ahead. Duty. Duty. Okay, go ahead.
If the lawyers representing parties know fully well that what they will be filing under Rule 45 will raise questions of facts, we do not outrightly deny it, Your Honor. We do not say deny PET and RE, but we must provide sanctions to these lawyers. That will deter the frivolous filing of petitions under Rule 45. A lawyer is expected to know the nature of his case. He should be candid and honest enough to his client that this case will not be entertained by the Supreme Court because the factual determinations of the three tribunals or three courts are binding on the Supreme Court. And if you insist to bring that petition to the court, we may face certain sanctions. And I don't want to risk that. That should discourage frivolous petitions reaching the Supreme Court. And I think that will be a good filtering mechanism also.
Okay. So you're the Chief Justice, you will have to do all of these things.
Well, subject to the approval of the court and bank.
Of course, but you have to lead. You have to lead. You have to be the chairperson probably of all these of the amendments of these rules.
In due time, Your Honor, God willing.
Okay. Now I have another question. I will be guilty if I will not ask this question because these are questions that are shared to us, and they would like to ask these questions to the applicants. But I simplify the questions because there are questions that should not be asked from the candidates. So I simplify the questions, and this is the usual question that they ask about SALN.
Yes, Your Honor.
Yeah, I think one of the members of the I heard, and somebody informed me that the question was asked also of Justice Bernade. But this one is a different question. It's about SALN, but it's posed in a different manner. The one who shared this question to me is like this. Because under our present system, we publish the network. It's merely the summary of what we had, and what are stated in the our SALN. So his suggestion is that would you be willing, or would the justices be willing, that instead of publishing the SALN, what will be published will only be the list of properties, real properties and personal properties, the classification of the property, the assessed value of the property, the market value, the location of the property, and the cost of the acquisition, and the mode of acquisition of the properties, and also the sources of income of the sitting justice and the spouse. And the question goes further that under Section 8 of 6713, there is, according to that question, there's a provision in Section 8 that all SALNs must be made public. And he quoted, I do not know if you agree with me that there is such a provision in Section 8, Republic Act 6713. And the question goes further that if we are dispenser of justice, and there is a mandatory provision of law like Section 8 of 6713, why should it be hard for us to comply with the law? So can you give me your idea on this or your thoughts on this, Justice Alex?
Your Honor, personally, I will have no objection. But at the moment, there is an existing administrative issuance of the court regarding the release of SALN.
Yeah.
Transparency is the rule, Your Honor. And I don't think there should be any objection on that aspect. They can possibly get the entire copy of the SALN, but you have to consider also, as we have said in our circular, that the purpose must be legitimate. The truth is that the justices of the Supreme Court are facing certain risk in the performance of their duty. But if the intention of getting details about the SALN is laudable and legitimate, then there should be no problem for giving them access, Your Honor. That's my point of view on this issue.
Yeah. To the honorable members of the JBC, that's all for me. Thank you, Justice Alex. And
Thank you, Your Honor. Thank you.
I will have to go to the other room to finalize the rules that we are drafting. So thank you. Thank you very much, and good luck.
Thank you, Mr. Chief Justice.
Thank you, Chief. The next to interview the candidate is the Honorable Judge Franklin J. De Monteverde. Judge De Monteverde, sir.
Thank you, Attorney Ed. Good afternoon again, Justice Esmundo.
Good afternoon, Your Honor.
Yeah, okay. I was going over your professional background, and I must say that the same you say that you have a very varied professional career. Now, do you think that the experiences that you gain from it can help you effectively manage the Supreme Court?
Yes, Your Honor. I would say that I would have varied experience. I finished economics with a bachelor's degree.
Okay.
I work in a publishing company and therefore harnessed the skills in writing and communication. I worked with a foreign embassy where I work as a marketing officer doing research. In the same office, I worked as a the research officer. So that's the fact that I have been a professor of law for quite a time in different law schools. So I would say that this varied experience more or less will equip me in performing my task if given the chance to be the CJR.
Okay. How long have you been teaching law, Justice?
Your Honor, I started teaching law way back in 1992, and I think I stopped when I joined the Supreme Court in 2017. Quite a time, Your Honor.
Okay. You are 64 years old now. And should you be appointed Chief Justice, you will be serving for the next 5 to 6 years. And that is quite a long time, considering the turn of Chief Justices that we have experienced lately. Now, considering the span of time that you will be serving, do you have any particular programs or projects that you would want to rather introduce in the judiciary?
Your Honor, one of the things that the JBC required me is to submit to the council the proposed short and long-term action plan.
Yes, yes.
And I understand that members of the council were provided with a copy. And set forth therein are the things I want to consider as major things that we have to be addressed. And I have provided a timeline and a roadmap within which these activities can be undertaken. You will notice that in the text of my submission, I may be allowed to go over it. Two things.
Yes, please. Please.
Stand out. First is the development, establishment of an ICT infrastructure for the Supreme Court. That is crucial. The short-term and the long-term projects that I envision in the action plan hinges on the establishment of the ICT infrastructure.
Okay.
The ultimate goal is that the court should be technology-driven, Your Honor. The other one is about review and assessment of the organizational setup and structure of the entire judiciary.
Now, you also made mention of your short-term goals.
Yes, Your Honor.
Can you cite a few of these?
Well, the short-term goals, Your Honor, first is the creation of the Judiciary Operations Manual that will serve as a tool on the transparency and accountability, but inform different stakeholders in the administration of justice on how the court operates. The creation of the enterprise resource planning that will integrate accounting, finance, human resources system. At the moment, Your Honor, some operations of the court, especially the Supreme Court, are said to be computerized. But the status is that there is no interface or interoperability. They are standalone operation systems. So with the building of the enterprise, the ICT, all of this should be interfaced and then interconnected in the sense that, the output of these different offices can be uniform in the sense that they are coordinated to a certain extent. The other ones that I propose. Sorry, Your Honor, there was interruption. Anyway.
Okay, go ahead. Go ahead, Justice.
as far as the Supreme Court and Bank is, as I was saying, the Honorable Justice Noel and Justice Mendoza, having been part of the court, would notice that administrative matters are rappelled individually, itemized in the agenda as one item, and these are concerning approvals of retirements, purchases, paying of utilities, so on and so forth, and other sundry items. My suggestion is that all the administrative matters should be reviewed by a committee of justices, and then upon their review and recommendation, they can submit it to the court and bank only under one item, because the end bank can either approve, disapprove, or modify the recommendations. So the number of items in the agenda for administrative matters, which will take one by one and be called again sometimes, will be just one item subject to the approval of the end bank. That's one suggestion.
Okay, let's go to your long-term goals, Justice. One of which is the possible utilization of artificial intelligence. What is this all about, Justice?
Well, the ultimate goal, because the short term and the long-term plan is a work in progress. In fact, it should continuously moving up, achieving a specific goal. And at the end of the plan, one of the objectives is that the utilization of AI. Many jurisdictions have been using AI. In fact, I think in the United States, some courts are using AI to compute the penalty that may be imposed, given as AI will greatly assist in the performance evaluation, because historical data can be gathered and from which we can assess or determine the trend with the specific information that we want to do. AI technically, they would say, is human thinking. But the reality is that it will simply assist us, because what data will provide to the system, AI will simply assist. AI has different features. It has address public assistance. It can help in fiscal and financial operations of the court, because it can detect misappropriation, fraudulent transactions, and human intervention, among others. The AI is the ultimate of the technology that we are trying to develop in our court.
Okay, Justice, I have here a question contributed by retired Justice Bienvenido Reyes, which goes this way. Justice delayed is justice denied is an oft-cited legal principle when the subject of administration of justice is brought up as a topic. This signifies that justice does not lie on rendering decisions alone, but equally so that it is done expeditiously. This is because when the delivery of justice is too slow, it deprives the prevailing party, notwithstanding his victory in litigation, of the opportunity to enjoy the fruits of that victory. It thus becomes an empty success, with the party reaching the end of litigation but achieving practically nil. What will you do should you be appointed as Chief Justice to obviate this lamentable situation?
Your Honor, the issue of speedy disposition of cases has been a recurring issue so many years, perhaps even before I became a lawyer. Presently, Supreme Court, with the amendments effected in the rules of procedure, specifically the rules on civil action, has already tremendously improved how a case should move. That's a special civil action. If you look at my innovation proposal, it is my view that the procedural rules intended to speed up the disposition of the cases is not enough. It must be complemented by an efficient operation of our court system.
Okay.
So they must go hand in hand. The issue of speeding up cases, as I said, are already addressed in the revisions of the rule. So, on the other hand, we have to address the counterpart, which is the operation of the courts. And using technology, perhaps, would be able to improve on how the speed of justice is to be addressed. Okay na? Thank you, Your
Okay,
Honor.
okay na? Okay na?
Yes, Your Honor.
Okay na, Leia? Justice Asmundo, you hear
Yes, Your Honor.
me clearly?
Yes, Your Honor. Thank you.
Okay. Let's go back to my question. What can the judiciary contribute to preventing the spread of COVID-19 without sacrificing the disposal of cases and safety of its employees?
Your Honor, when the COVID pandemic started March of last year, I think everybody was flat-footed. But still, the Supreme Court, with the initiative of the Chief Justice and members of the court, tried to address the issue of how the court should work despite the pandemic. Remedial measures were taken immediately, Your Honor. We allowed video conferencing for purposes of conducting proceedings. We allowed electronic filings so that pleadings can be filed with the court. And precisely, my suggested plan of action, short-term and long-term, would cover also addressing risks that may arise in the future. Because whether we like it or not, it has been often said now that this pandemic will not be the last, but may recur worse than this. And part of the review I am recommending is precisely to address situations like this using technology.
Especially now, Justice, that there's an upsurge in new COVID cases now.
Agree, Your Honor. And we have been adopting measures like in the Supreme Court now. Initial measures like, cutting the numbers of staff that should report to court so that the social distancing is also. Well, there's a plan for the court to acquire vaccines to ensure that at least employees of the judiciary are able to have it as a preventive measure.
Justice, what is your leadership style? And how do you plan to lead the judiciary with that kind of leadership?
Your Honor, leadership is being able to show that you have the moral and ethical values. In other words, you should be the exemplar of moral and ethical values. Second, leadership should be able to provide direction. Leadership should be able to provide political will. A leader, a Chief Justice as a leader, should be able to show that one, he is participative, and at the same time, consultative. That's the essence of a leader in the judiciary.
And you hope to lead the judiciary under your term with that kind of leadership?
Yes, Your Honor. The leader in the judiciary should be one who should be steadfast and firm in undertaking his own duty under the Constitution and the law.
You know, the Chief Justice Peralta has been a very, very effective Chief Justice, and he is a hardworking one. would you be assimilating his kind of performance, or would you rather expect to surpass it should you be appointed as one?
With your honor, I can do and have worked with him also during his tenure. And I think if it comes to the point that I will be heading the court, I can possibly achieve and improve on what he has accomplished with the support of the court staff.
Okay, Justice. Now, if appointed, you will be the face of the judiciary for quite some time. And as such, how will you address the public's perception that members of the High Court are just followers of the present administration, as had been the impression under the previous administrations?
That is a public perception, but you can have that perception by showing that the courts decide on what is proper under the circumstances. The court should decide on the basis of what is before it in terms of issues and laws applicable. People may have different perceptions, but what matters is that the court is doing its job properly. I think that's the more important thing to consider.
How about the continuous public's perception that the judiciary is a corrupt institution? How will you address that?
That issue has been cropping up as far as many years.
Yeah, time and again it crops up.
And again, maybe even during your time when you were a judge or even a law student. But with the establishment of the Judicial Integrity Board, now in place, fully complemented, these issues will be properly addressed.
Okay, Justice, you mentioned the Judicial Integrity Board. What is that all about?
When it was created, giving credit to whoever it's, it was conceptualized during the time of Chief Justice Lourdes Sereno. I was part of the technical working group that studied the feasibility of putting that office. The JIB would have two different offices: the Corruption Investigation and Prosecution Office, and the Office of the General Counsel. The powers and responsibilities of the JIB, in a way, to summarize, is precisely to address the issue of corruption in the judiciary. There is given extensive power. The manner by which they conduct investigations are so wholesome and should be, I think, available and sufficient to address this issue of corruption in the judiciary.
With the establishment of the Judiciary Integrity Board, Justice, are we to understand then that all complaints against the judges and other justices of the other departments, of the other levels, will be filed directly with this GIB?
Yes, Your Honor. Practically, all complaints, even anonymous complaint, can be addressed with the GIB. But the processing will differ because we have set a demarcation line on the basis of the salary grade and position, so that there are officials that are covered by the GIB per se, and there are officials or employees that remains to be with administrator. But the essence is that everything should go to the IB, who should conduct the investigation and proceedings under the given nature of the case filed against an employee or officer of the judiciary.
Okay, Justice. Now, as Chief Justice, you will also be the ex officio chairperson of the JBC. What will be the future of this office under your watch? And what reforms do you have in mind?
Again, Your Honor, as I said earlier, in the short-term plan, the second most important thing is the review and assessment of the organizational setup of all offices in the judiciary. This of course include the JB. One of the things that I am looking to is to be able to see the setup with respect to manpower or support staff. Likewise, we should look into the scale of officials in each office under the judiciary or the Supreme Court. I was given the impression that different offices would have different pay scales and different ranks. So perhaps I would look into that and perhaps harmonize the qualifications, salaries, and whatever standards that are necessary among the different offices of the judiciary, so that there should be no disparity because each office, I understand, performs unique functions in the scheme of the judicial system.
Now, a big factor in the performance of the works in the judiciary is its people or employees. Will you encourage skill-based trainings for the court employees, and do you have other plans for them should you ever be appointed?
With respect to training of employees, again, it hinges on the assessment and review, because at a certain point in time, knowledge taking place in the operations of the court, we have to retrain our employees to be able to be adept with the technological developments or technical operations of the court using the technology. I don't foresee any problem retraining them because we have the Philippine Judicial Academy that can provide the training. In other words, it's like something like retooling the system to improve on its operation.
Now, here are some questions being recommended by the Chief Justice. First of which is, why do you think you should be the next Chief Justice? And how are you better, or what distinguishes you from the other aspirants?
Your Honor, the basic qualifications are possessed by each and every applicant. But I think what is important is that you believe that you can contribute to the improvement of the judicial system. I respect the seniority issue, and for me, I will be able to contribute immensely in terms of how we can possibly improve better the performance of the judiciary in the scheme of government.
Now, recently, there has been a spate of attacks against lawyers, both in the government and in the private practice, and those involved in public interest cases. Considering that the Supreme Court has supervision over all lawyers, and as the future Chief Justice, how would you address this?
Your Honor, it is a sad commentary in the present history of our country that these killings of people involved in the legal profession, people in the judiciary, are occurring. And I think the thing that we can do, having a supervisory power over the legal profession, is to immediately talk with the law enforcement authorities and perhaps require that they give us specifics on the extent of the investigations that have been conducted as regards this killing of legal members of the legal profession. And subsequent to that, perhaps we can have a dialogue or discussion with the Integrated Bar of the Philippines to sit down and discuss how can we possibly address these issues of killings of lawyers and even judicial officers. The key here...
Yes, you spoke, or you mentioned a bench and bar dialogue. I can remember that when I was the president of our chapter here, IBP, the Supreme Court had a program of a bench and bar dialogues between the IBP and the court. I don't know what happened then, but that was no longer effectively administered. So you have plans of reviving that kind of practice, Justice?
We will report the bench and bar dialogue only once a month, but practically as often as we need to meet up to be able to hear from the members their concerns regarding the operations of the court, as well as the concerns of officials and employees. The sooner you know the problem, the sooner you can solve it.
The continuous trial in criminal cases and the 2019 amendments to the 1997 revised rules of civil procedure mandated timelines in the trial and resolution of cases in the trial courts meant to expedite the resolution of cases. Are you amenable to the adoption of timelines at the Supreme Court as well?
Yes, Your Honor. In relation to the questions raised earlier by respect to the 24-month period, as I said, that is feasible. Certain if we adopt a system that, like filtering mechanism, as I said, again, reiterating the ruling of the Supreme Court in Gio Summer case, that 24-month period could be achieved, because I don't see any reason why the members of the court cannot impose self-discipline in their disposition of their cases.
My last two questions, Justice. No?
Yes, Your Honor.
In 2012, after former Chief Justice Renato Corona was removed from office, the Supreme Court justices released their salents to the public. This step in the right direction for transparency was unfortunately never repeated. What is your take on requiring justices to annually release their salents to the public?
As I said, again, on the question of the Chief Justice earlier, there's an existing administrative issuance or guidelines which are salents of members of the court. And I said earlier that personally, I would not be averse, but still, it is subject of the approval.
Mm-hmm. Okay. Are you willing to allow the AMLAC to look into your bank deposits and acquisition of assets at any time during the incumbency as Chief Justice?
Yes, Your Honor. When we filled up our PDS, I suppose we executed a waiver for purposes of processing our application. And I don't see any reason why, in the course of the incumbency of the court, why should you not allow AMLAC if they have very basic suspicions? That should be no issue for Honor or Your Honor, for those who are not really for the members of the court concerned. And yes, I'm willing to have.
Okay, Justice, that was my last question.
Thank you very much.
Thank you for your time also, and good luck.
Thank you very much, Your Honor.
Okay.
Thank you, Judge De Monteverde.
Okay.
The next to interview the candidate will be the Honorable Justice Noel Jimenez Tiham. Justice Tiham, sir.
Thank you, Attorney Ed. Good afternoon, Justice Alex.
Good afternoon, Justice Noel.
The Judicial Integrity Board does not investigate Supreme Court justices. So how will you make members of the High Court accountable if they can be investigated although there's a committee on ethics in the court, do you think that is sufficient, an adequate mechanism to make members of the High Court accountable?
Yes, Your Honor. Committee on Ethics as presently constituted and with the clear-cut uh, clear-cut agreement during the deliberations on uh, the the convening of the Ethics Committee. The courts have agreed, the members of the courts agreed among themselves that they allow themselves to scrutiny by the Ethics Committee. In fact, when we created the committee recently, there was a recommendation that Justice Arturo Brion should be the consultant of the committee.
You also mentioned using technology. Can you use technology to effectively monitor court operations short of installing CCTVs in all courtrooms throughout the Philippines?
Yes, Your Honor. In fact, way back 2007, that's what I was saying earlier that we're lagging behind. In one of my study tour in Korea, they were able to show us how technology works. At any given time in the Supreme Court, they can see the actual court proceedings at any court in any part of Korea by video. They can hear the witnesses, the proceedings and everything. They can even see what kind of evidence is being presented. Judges are not required to report to Seoul for conferences. These are all done by technology. In Korea, for example, Your Honor, unlike in the Philippines, and I think we are still far behind, you can go to a machine, something like a bendo machine, and you pay, put the coins, and then you can have a copy of your transfer certificate of title, similar to that. And this is authenticated and officially recognized by the court in Korea.
I suggested in the JBC to interconnect with the Supreme Court in the Philippine Judicial Academy so that we can share information regarding matters of common concern to said offices. And we can even share records of incumbent judges so that the JBC will be guided with respect to applications for promotion by incumbent judges. Would you be in favor of that kind of interface or interconnection?
That's the main objective of my recommendation in the long term, that there should be interconnectivity, interface among the different offices of the courts, so that accessibility of information, data, will no longer be difficult. That's the idea of having an ICT infrastructure and what we call a business enterprise driven by technology. There will be no problems accessing any information for as long as it's within the database of the judiciary, Your Honor.
The physical and mental health of judiciary employees, and with more reason, judges, magistrates, are very important. How do you intend to monitor, to safekeep, and promote the physical and mental well-being of people in the judiciary?
Your Honors, ordinarily, we subject ourselves to an annual physical examination to determine the status of our health condition. And I do not see any reason why we cannot allow or even fund the annual mental and physical examination of court officials and employees. That is a very important determinant in the smooth operations of a court. Healthy.
The isolation, the quarantine of court personnel, employees, and magistrates have also affected the mental health of a few. Uh, in our psychological evaluation of even applicants in the judiciary, there are instances wherein certain applicants are red flagged because of deficiencies in their mental health. Uh, are there any concrete or specific measures you have in mind, not only to monitor, but to see to it that the mental health of court employees are taken care of?
Yes, as I said earlier, Your Honor, we can perhaps provide annual mental exams, diagnosis of each employee of the judiciary.
Anger management is important for judges.
Sorry, Your Honor.
Anger management. Anger management, because there have been complaints from lawyers and litigants about abusive judges inside the courtroom. That is also very important. And that is something that needs to be addressed. Now, let me go to the topic of judges at large. As Chief Justice, what are the parameters you have in mind insofar as deploying judges at large in courts which are in need of them?
Precisely, Your Honor, the intention, I think, of creating positions for judges at large is to assist those courts with heavy dockets or workloads. So the primary consideration is the assessment of which court in our country or each branch of court in our country that needs the assistance of a judge at large. That should be the primary consideration, Your Honor.
Will you be deploying judges at large first to courts which are vacant?
No, Your Honor. I would deploy judges to those cases, those courts that are heavily with workload or congested docket.
Now, there's a question about security. If and when the judicial martial bill is finally enacted into law, there is a question from the lawyer sector whether trial lawyers appearing in court can similarly benefit from security measures derived from judicial marshals. And there was even a dean of a school from the academe who wanted that lawyers in the academe who are also appearing in court should similarly benefit from security measures given by judicial marshals. What are your thoughts on that?
Your Honors, I think the creation of the judicial marshals is primarily intended for the protection of the courts and the members of the courts and the court employees. In other words, they are geared toward protecting the judiciary, its members and personnel. Why?
What is your advice, Your Honor, to lawyers who are at risk of physical harm, assault, and even death when they appear in courts? And there have been cases of lawyers who died in line of duty. What is your advice to them?
I think there is such an office under the PNP, what we call Police Protection and Security Group. If I'm not mistaken, that if there is an existing threat, they can request for assistance. So that should be addressed to this agency of the PNP that can provide them this kind of protection, especially.
Will you encourage lawyers to carry firearms while going to and from the courtroom or while going back to their homes or offices?
Yes, Your Honor, if they feel that they're adequate to handle firearms, they should be allowed. They should be allowed to carry firearms outside of their residence if they think that is the best way they can protect themselves from the threat.
Now, let's go to an area which is close to your heart, legal education. The court has decided in the case of Pimentel et al. Versus Legal Education Board. Now, just for clarity, you issued a concurring and dissenting opinion. Can you briefly tell the public your views on legal education?
Well, legal education is important, Your Honor. Legal education is so important that it is the very basic thing that an aspiring lawyer to acquire. Legal education at this point in time is under the auspices of the Legal Education Board. That law was passed intended to regulate and accredit law schools operating in the country. Legal education is important because, as we have been saying, the practice of law is imbued with public interest. So we must see to it that those aspiring to be lawyers would have a strong educational foundation, and this they acquire through pursuing a law degree. For that purpose, I think the court, somewhere, somehow, have introduced certain revisions in the rules of court concerning how to improve legal education in our country. We consider that part and parcel of learning the law is that lawyers should be trained to be aware of their certain social responsibility. Lawyers are not there just to practice for the interest of their clients, but they should be motivated that they have responsibilities also to the community, specifically when they live. They should be able to provide legal services to those considered to be part of the marginalized sector of the country.
But is there anything left for the Legal Education Board to do?
Yes, sure.
That law schools are supposed to be within their domain. They're supposed to enjoy academic freedom, correct? Then you have the Supreme Court. So what else is given to the Legal Education Board to do?
The charter of the Legal Education Board enumerates certain powers, but basically, this is with respect to accreditation and making sure that the law schools operating are within a specific standard in terms of facilities, enrollment, complement of faculties. They can regulate that area, Your Honor. They can withdraw accreditation if the specific law school ceases to meet the requirements of how a law school should operate.
Let me go to another topic. Is judicial activism similar to judicial legislation, Your Honor?
Well, when you speak of judicial activism, the magistrate or the judge will put into his decision which are his personal political views. That's the essence of judicial activism. Judicial legislation, on the other hand, is when the court interprets a law, okay, what is not in the law, and interject its own belief that what should be there in the law.
I ask Justice Telly the same question. Will you encourage or discourage judicial legislation in the High Court?
No, Your Honor. That will be out of the bounds of the Supreme Court. Engage.
Since judicial legislation violates the Constitution because it infringes on the doctrine of separation of powers, do you think that judicial legislation amounts to culpable violation of the Constitution and therefore an impeachable offense?
No, Your Honor. Sometimes in a decision, there's such thing as obiter dictum. And perhaps the keen interest of a magistrate in writing his opinion may have extended out of the bounds and may be viewed as statement of judicial legislation.
So what is the remedy? What is the remedy against judicial legislation aside from ignoring it as merely obiter? What is the remedy?
Congress can legislate on those matters that are considered to be judicial legislation on the part of the judiciary. Because judicial legislation technically provides something that's not in the law. So if the reason or the rationale or the ratio decidendi of the decision is to call the attention of Congress to pass a specific law as reflected in the decision, then Congress must address that.
It was reported in the news that Justice Marvick in the 3rd Division promulgated a decision in the case of Alanis versus Court of Appeals. I don't think you're a member of that division, Justice, correct?
I'm not a member of that division.
You're a member?
No, I'm not.
You're not a member. And it was reported in the media that the Supreme Court held that a legitimate child may use his or her father or mother's surname as the law does not mandate the use of the father's surname exclusively. All right, which there's nothing wrong about that because even previous decisions of the court stated so. But the decision, we are not trying to cast aspersion on the ponente, and even on the merits of the case, but the decision proceeded to discuss gender equality when it was not the issue. Purely for academic discussion, does it qualify as judicial legislation? Because seemingly the impression brought to the public upon reading the newspapers, and we're not blaming media, what they published, is that it is now permissible, it's a choice, whether to follow the surname of the father or the surname of the mother, when in fact, the law and jurisprudence says when there is a justifiable reason for doing so. But when the ponentia extensively navigated into the area of gender equality, did that in effect muddled into the area of judicial legislation?
I have not thoroughly read or encountered the decision by Your Honor. When you cite those issues, I think that's basically laying the groundwork to be able to view the issues presented in the case in a more broader perspective. And that because I would suppose that he cited either certain laws or conventions to the effect that there's such thing as gender equality. That's, I think, the reference to those conventions or maybe legislation is just a preliminary statement, Your Honor.
You have heard, and you have probably read about the Equality Act in the United States, which is to promote gender equality. The bill would end federal legal recognition of complementary male and female sex in favor of gender identity. They will have even allow males and females to use the same bathroom or things like that. If a similar bill is passed in Congress without the participation of Congressman Ching, of course, and it becomes a law purely for academic discussion, would that be constitutional or unconstitutional?
Well, to be able to resolve it, Your Honor, I will need the facts. I will need the facts. There should be underlying facts on how to resolve that particular issue. And I will wait until such time that that issue is brought to the court. Because
as Chief Justice, I ask this common question. Are you willing to adopt the principle of deciding a case even if it is moot because it is capable of repetition, evading judicial review?
Yes, Your Honor. I will subscribe to that idea that a case, even if moot, should be resolved to evade, to prevent, again, that issue coming up to the court again and again.
Is this not a departure from the guidelines laid down in Geo Summer, penned by Justice Ardilesa?
I don't think so, Your Honor, because capable of repetition is something that needs to be, in other words, we try to stop that issue from coming up, because while we may dismiss the case now because it's good academic, that particular issue may crop up later. So it's better addressed now so that that issue will be prevented from going back to court. So I'm not...
So can petitioners invoke that principle in the absence of an actual controversy?
No, Your Honor. Courts cannot entertain petitions without actual controversy.
Just purely for academic discussion, and you may choose to decline to answer. Can that be invoked in the petitions pending before the court on the anti-terror law?
I will refuse to answer that, Your Honor.
Right, thank you, Justice Alex, for your time, and good luck.
Thank you very much, Justice Noel.
Thank you. Thank you, Justice Tiham. The next to interview the candidate will be the Honorable Judge Toribio Ilaw Jr. Judge Ilaw.
Yes, thank you. Thank you, Attorney Aricheta. Yes, good afternoon, Justice Alex.
Your Honor.
Are you tired?
Well, not really, Your Honor. It's just, you know.
You need a break just to relieve yourself.
No, Your Honor. I'm okay. I can continue with the interview. Thank you.
Excuse me. All right. What moved you to apply for the Chief Justice position this time around?
Your Honor, I honored the endorsement and the invitation of the JBC that I am part or among those who are considered for automatic nomination.
What do you like most about serving in the Supreme Court?
The challenge of working non-stop.
By the way, how is your physical health with high glucose and uric acid?
Well, the high glucose level, Your Honor, is expected because I am a diabetic. And usually, because of the medications perhaps I'm taking, the higher level of uric acid comes as a matter of course. But I think that the latest lab work on my sugar level is close to the range for people with diabetes. Less than 7%, I think. I'm not so sure. But it's not that much higher than the, it's not that high for purposes of assessing whether the diabetic is such a degree of disease that is considered to be, I would say, a dangerous level, I think.
Do you think that life is too serious to be taken too seriously?
Yes, Your Honor.
Well, it's because reporters observe and ask, why don't you smile in pictures? I did a good. And that's.
Thank you, Your Honor. But I think it's my nature that when I talk to people and listen to people, I would rather to be looking attentively, because that's how I be able to catch the attention of the person I'm talking with. It's not that I don't smile and I don't laugh, Your Honor. I do laugh. I make fun. is to that I usually break jokes with them.
All right. I heard that when asked by Chief Justice regarding SALN that has to be published, and you don't have any objection to Justice's SALN to be published. Now, going over your records, could you explain the discrepancy in your declared cash as stated in your 2019 SALN and in your PDS?
Which one is that, Your Honor?
14 million cash in 2019 SALN and 22 million in February 2021 PDS.
Your Honor, I think the difference is that the one you're talking to in the Stalin is a year-end figure. On the other hand, the other figure you're looking at is based on the requirements of the JBC. You should state the latest amount of deposit. That explains the discrepancy, Your Honor. But let me take a look. Because 2019 is the end year covered for the filing of SALN. And then the certification that was required of us is the deposit required as of the date of the acquisition of the deposit. (2019), Your Honor. Your Honor, as of December 2019, it's 14 million.
Yes, that's correct. How
And
about February 2021 PDS?
February 21, PDS.
No, it's February 2021 PDS. It's 22 million.
PDS. Let me check. At page 7, Your Honor, of the PDS.
Yes, please.
Yes, Your Honor. It says that the deposit with land bank is 15 million as of the date that I obtained the certification.
How about this 22 million in February 2021 PDS?
February 20. Your Honor, if you add up the amount stated in the PTS, it will be close to that amount of 22 million. 15 plus 4 is 19. 1 plus 1 is 29. 21 million. 15 plus 4 is 19 plus 2 is 21 million, Your Honor.
All right, thank you.
So it's a cut. The cut-off period explains the discrepancy, Your Honor.
There's really no question, advisability of questioning your integrity with respect to that. All right, at present, Justice, the United States Supreme Court decided to hear a case involving a case of student speech. The issue is whether the school may discipline the act of a high school cheerleader who published a profane social media post while out of school and on her time. In this jurisdiction, do you think that school administrators may regulate the speech of their students?
I don't think so. That will be like curtailment of the freedom of expression, especially considering that the student did that outside of his outside of the school, and during her own time. Unless the statements being made on the social media by that student causes or intended to destroy or damage the reputation of somebody else, then that will be another thing, Your Honor.
All right. Theodore Roosevelt once said, a man who never graduates from school might steal from a freight car, but a man who attends college and graduates as a lawyer might steal the whole railroad. What do you think this means?
It means the character of a person. The character of a person.
Character of a lawyer?
Of a person, Your Honor. Education doesn't mean the right thing. Sometimes the reality is that less educated people do better things than those who went to even a postgraduate study. So in other words, education is not really an essential determinant of a person's character.
All right. You mentioned that you propose to revisit the organizational structure of the judiciary, specifically the internal structures of the Supreme Court in relation to other main offices such as Office of the Court Administrator, Philippine Judicial Academy, Judicial and Bar Council, and external rules of the Supreme Court with the appellate courts and lower courts. Seems to be utopia justice. It entails sensitivity as well as the prolix process of gathering all cases. What seems to be the most foremost problem with the existing organizational structure of the judiciary?
Well, I think the reality is that we lack the technology to facilitate, enhance the operation of the court. I think most of the transactions are still done manually. Records are done, recording of transactions are done manually. At this point in time, these are, I will not say anachronistic, but too late already for us to continue adopt these kinds of system in operating our offices. So, technology provides hastening and efficient delivery of services.
You also provided a timeline for the completion of your proposed plan of action that is ranging from 1 to 10 years.
That's correct, Your Honor.
How confident are you that you will be able to undertake those projects?
Your Honor, with the support of the court and bank and all the officials of the court, and perhaps with the support of our development partners, we will be able to achieve those goals within the time frame set. There could be delays, but I am optimistic that with the full support of the court and bank and the officers and employees of the judiciary, we will be able to achieve that target.
Among your proposed plans, what do you think is the most challenging one to fulfill?
The infrastructure construction of the ICT in the judiciary, because that will entail a lot of funding and a lot of adaptation to technology, which is quite expensive.
What are the important realizations in this pandemic?
Sorry, again, Your Honor.
What are the important realizations during this pandemic?
Well, basically, as far as personally I'm concerned, the realization in this pandemic is that we are not immortal. We are not immortal. No one is immortal. You must have read the reports that rich people, powerful people became the victims of COVID-19. And it chooses it chooses not the victim. You know, in other words, we human beings are vulnerable, and at any given time under the pandemic, you may be called upon by your creator.
All right, with regard to the service delivered by courts during this pandemic, are you satisfied with the e-filing system and video conferencing adopted by the courts?
Yes, I palliative measure to address the current issue. But as to the permanently adapting it, I would say it will need a lot of improvement. That's precisely, Your Honor. In my strategic plan, I have emphasized the need to put up the ICT infrastructure of the Supreme Court. Call it palliative because it merely addresses a specific issue that is before us. But the long-term solution isn't there yet, Your Honor. So we have to improve on what we have done in this situation, the pandemic situation, as to make the court operational despite the pandemic.
Are you in favor of extending the term limit of Supreme Court Associate Justices?
Personally, Your Honor, no.
Why? 70 years.
Your Honor, I think a person can have a long productive life in work. But at a certain point in time, you have also to choose your priorities. So that, you know, extending the term of justices beyond 70 years will be counterproductive in the long run. I think even the United States, they have experienced that, you know, since justices can serve until good behavior, no age limit, they say that at a certain point in time, the productivity of a justice starts to wane and go down. We must,
Right. Sorry.
we must realize our physical limits, Your Honor.
All right, to be truly independent and co-equal branch of the government, do you think that the Supreme Court justices should also be elected by the people?
No, Your Honor. I cannot subscribe to the idea that justices of the Supreme Court should be elected for the reason that our culture, when it comes to election, is different from that of Western countries, Your Honor. I think if you make election as a precondition to getting a seat in the Supreme Court, to a certain extent and perhaps, and not surprisingly, independence will be compromised.
Let's have some points for discussion regarding the Legal Education Board.
Yes, Your Honor.
On March 10, 2020, that was last year, the regular members of the Judicial and Bar Council sent a letter to Congressman Ching Veloso narrating the problem of the JBC in filling vacancies for the Legal Education Board. In that letter, the members requested the Congress to aid the JBC by abolishing the Legal Education Board and creating an office under the Supreme Court. with similar functions. Taking into consideration the functions which were declared unconstitutional by the court pursuant to Section 5 of Section 5, Article 8 of the Constitution, or reducing the number of the Legal Education Board members and taking other measures, such as having the representatives of the IBP and the Philippine Association of Law Schools serve in an ex officio capacity, who will therefore automatically serve without undergoing the selection process of the GBC. Second, removing the preference of the Supreme Court and the Court of Appeals justices to chair the Legal Education Board to encourage more applicants. Number three, reducing the required teaching experience from 10 years to 5 years to qualify and encourage more applicants. And other measures that would empower the Legal Education Board without impinging on constitutional freedoms and thereby encourage more applicants and improve the legal education's structure and system. And there are various advantages as well why the Supreme Court is better off having control over legal education. And I browsed about your dissenting opinion. The study of law is affected when you stated that one way or another by the court's rulemaking power. Would you agree that a new law could also correct those powers and issuances of the Legal Education Board that were to be declared unconstitutional? And take note the learnings from the Legal Education Summit to effectively enhance legal education all over the country. In that case of what are your further thoughts on this?
If we are to say that academic freedom must be extended to an institution of higher learning like law schools, I will not be averse if they decide to abolish the LEB. On the other hand, it is also important that there should be an office under the executive to monitor the law schools, not to control, but to supervise. Because the reality is that there are still a number of underperforming law schools, schools that do not have the facilities like books and libraries that is necessary to provide a good legal education. So it's a question of a balancing of interest. Do we abolish to fully sustain the thought of academic freedom? Or do we maintain the LEB for specific purposes of regulating and accrediting law schools? That's a question of policy that should be addressed by Congress.
All right, my last question, Justice.
Thank you, Your Honor.
You can start a fire if you have alcohol, petrol, kerosene, paper, and a box full of match. What is the first thing you light?
The first thing I light, Your Honor, gasoline or kerosene. If your intention is to burn, that should be the first you have to, because of the viscosity and the chances that it will really light up. Paper would be not a good combustion material. So if you want to really light up something quickly, you can go to gasoline or the kerosene.
Don't you think it's better light a match?
Oh, yes, sir. That's a given. I'm so sorry.
Thank you. That was my last question. And that's I know you're tired, very tired, Justice. And good luck to your journey.
Thank you very much, Your Honor.
You're welcome. Thank you too.
Thank you, Justice Ilaw. The next to interview the candidate will be the Honorable Justice Jose Catral Mendoza. Justice Mendoza, sir.
Good afternoon, Justice.
Thank you, Your Honor.
As you know, I represent the retired justices of the Supreme Court, and they requested me to ask questions to you.
Yes,
But before that, I may forget the other. I intended to ask you about the LEB, but you were already asked by extensively by Justice Tiham and Justice Ilaw. I just want to mention that there is now a bill in
Please.
of the LEB be placed under under the Supreme Court rather than the DEX. Are you in favor of that?
Your Honor, I think the Supreme Court will have difficulty running law schools and supervising law schools. The Supreme Court is the primary task is to administer justice, and putting the LEB under the Supreme Court will be a task that is far distant from the main function of the judiciary. Because you were talking of several schools all over the country, and you may report the regulator of those law schools is quite something that is not within the sphere of competence, perhaps, of the judiciary.
So you want the Supreme Court to be limited to the admission to the bar only,
Yes, Your Honor.
not the supervision of the law schools.
Your Honor.
Oh, we are just wondering why the case of Aquino versus Lev is still pending. Dean Marisol Ananias, president of the Philippine Association of Law Schools, also sent some questionnaires, and I said they have filed a petition in intervention advisory positions. What is that? What is that petition in intervention advisory position? I cannot.
Basically, Your
We have
Honor,
no access to it. We have no access to it. That's why I'm asking you about it, because last week we vetted the candidates for the LEB, but this is the first time we have encountered that a petition for intervention intervention by the PALS, who is not an original party in the case. This is already the stage is already second motion, first motion for reconsideration.
Your Honor, the Philippine Law School initially wrote a letter to the court asking for some clarification on the decision rendered by the court in bank in that Pimentel case. And that they seek to clarify, I think, whether PhilSat should continue to be mandatorily required, or the passing of a PhilSat score of 55 percentile is still mandatory. But the case was overtaken by the retirement of Justice Joey Reyes, who was the original ponente. And it was rappelled to another justice at the moment. The question is, should the PhilSat continue administering the law school admission test? And if I recall it right, in their intervention, they recommended that the court, in resolving that issue, should adopt my recommendation as set forth in my separate concurring and dissenting opinion. Because in that my concurring and separate opinion, I said that the administering law school admission test should be made by the law schools themselves through PALS, the Philippine Association of Law Schools. They should be the one to design, administer a unified law school admission test, only to be supervised by the LEB so that the safeguards are adopted. I recommended that LEB should in no way be conducting the admission test for law school admission law students and should not fix the admission rate. The law schools themselves must do it, similar to other jurisdictions, Your Honor. Like in the United States, they have the ALCC, the American Law Admission Commission. They design, they conduct the test, and this is a group of law schools all over the United States, free of intervention of the government. Because when PhilSat was adopted, it became arbitrary in the sense that it is an exclusionary measure because PhilSat said and ruled in the memorandum order that 55% score should be the only basis for admission to law school. And I believe that is arbitrary because it deprives the law schools of the opportunity to choose the students that they will allow enrollment. This is basically we're saying is an encroachment to academic freedom. The four elements of academic freedom, Your Honor, is who may teach, what should be taught, how should it be taught, and who may study, who may be admitted to study. With that 55% gold standard set by PhilSat, that is an exclusionary rule because you deprive the school to determine who they can admit in their universities to pursue a law degree. Relying solely on that passing score, or rather the benchmark score, is arbitrary. Law schools, as a rule, would not limit the admission of law students on the basis of the admission test. They take into account the undergraduate performance of law students, the recommendations on the students, perhaps to a certain extent, the work experience of a student who intends to go to law school. By making 55% score passing for admission to the law schools, the schools are no longer given the freedom who they admit because they are limited only to those who pass on the basis of a 55% scoring. And that makes the PhilSat an exclusionary rule. That's why I said that is unconstitutional and that should not be permitted. Law schools should be allowed to design, conduct, and give their unified, standardized law admission test for those who intend to go to law school. That's the essence of, I think, what the PAL submitted by way of intervention in the LEB case.
Your Honors, the Honorable Justice Mendoza got disconnected. In the meantime, with your permission, Your Honors, may we proceed to the next interviewer, the Honorable Justice Vicente Veloso III, Attorney Aricheta.
Yes, Attorney Lela.
Justice Mendoza got disconnected po. May we proceed with the Honorable Member's permission to the next interviewer, the Honorable Vicente Veloso III.
Thank you, Mr. Chair. Good afternoon, Justice Alex.
Good afternoon, Your Honor.
Tagal na natin nakikita. I just would see you sa Ateneo Law School campus.
Yes, Your Honor.
And next, I heard you became Justice at the Sandigan Bayan. Next, you became Justice of the Supreme Court. But anyway, Justice Alex, a viewer wants me to ask you these questions. And this refers to your having been the chairperson of the Oversight Committee for the implementation of the revised law student practice rule, Rule 138-A of the Rules of Court. Because as you know, it's been 6 years or 7 years that I've been out of the judiciary and from teaching. And my understanding of this Rule 138-A is that, in a nutshell, a recognized law school can have a legal education program approved by the Supreme Court. And what is it all about? A fourth-year law student can appear without compensation in representation of an indigent client in any civil, criminal, administrative case. That is in Section 2 of Rule 138-A. Now, Section 3 says privileged communication between lawyer and client applies to a legal clinic student, and 4 ethical standards for lawyers also apply to legal clinic standard student. My first question, Justice Alex, is kindly educate me now about this amendment in 138-A, which you serve, or where you served as chairman of the Oversight Committee for its implementation. As to concept, Justice Alex, what do we have under revised Rule 138-A?
Thank you, Your Honor, for the question. Let me give you a brief background that resulted into the amendment of 138-A, which is now called the Law Student Practice Rule. I think in 2018, then Associate Justice Lucas Bersamin and a number of law deans and some lawyers from the Supreme Court, including me, went to the United States on what we call a learning visit sponsored by the United States Department of State, Bureau of Narcotics and International Law, and the Asia Foundation. The purpose of the visit was to be able to get familiarity of the current state of legal education in the United States and what emphasis is being focused on by these law schools. On return to the Philippines, Justice Bersamin taught, who then later became Chief Justice, that we need to assess the status of legal education in the Philippines. So another committee was created, which we call the Technical Working Group for the Conduct of the Legal Summit, because it was believed that a legal summit is necessary precisely to bring into all the stakeholders in one venue and let us know what is the current status of legal education. Antecedent to the legal summit, the Technical Working Group conducted regional consultative meetings with all the stakeholders in legal education. I think we had 7 regional consultative meetings. And from those consultative meetings, 2 came about as the issue that besets legal education in the Philippines. First is the apparent lack of ability of even law graduates to communicate, which perhaps explain why the performance in the bar are not that good. Second, even law graduates would have limited skills in appearing before courts. So to address those issues, we thought of revising 138-A. So during the legal summit, we presented these issues. And what we found out is that one of the effective ways of addressing these inadequacies in terms of training future lawyers uh, studying law is the adoption of what we call Clinical Legal Education Program, or known as CLEP. When we revised 138-A to address those inadequacies, we provided for 2 levels of certification by which a law student can engage. Certification level 1, which is available to those that completed at least a freshman or a sophomore year, will be given an opportunity to develop their communication skills because they will be allowed to conduct seminars, trainings, write position papers on ordinances affecting their community. So both written and oral skills will be developed. The second level certification, / certification level 2, is much different from the old rule under 138 SA. This time, the law students learn the actual skills in court proceedings outside the confines of a classroom. Because we know for a fact that actual court experience, as far as law schools are concerned, are limited to moot court practice. But with certification level 2, the law students, under the supervision of a supervising lawyer or attorney, will have the opportunity to write pleading and sign by him. In other words, his writing skills on pleadings will be developed as early as when the student is in law schools. Equally important to that is that they will be allowed under certification level 2 to appear in court, similar to that of a lawyer, of course, under again the supervision of a supervising lawyer. They can appear, and if you will notice under 138-A, a law student practitioner is required to take an oath exactly the same as that of one who just passed the bar. They are accountable for the same responsibilities, similar or exactly the same as that of a member of the bar, to instill the responsibility that they are doing something similar to that of a lawyer, and they are bound by these duties and responsibilities. In fact, if they violate those provisions on the 138 as to their responsibilities, then there are appropriate sanctions like this, allowing them to take the bar examination. The clinical education program under 138 in relation to the provision of 138, 138-A in relation to 138 now requires that law students taking the bar starting 2023 will be required to have completed clinical education courses. What is this clinical education? Clinical education is conceived similar to that of in a medical school you have residency or residency and internship. In clinical legal education, law schools are mandated to provide and establish law school clinics in their respective law schools, precisely to enable the law students to experience the venue similar to that of a first responder, where an individual in a community would have legal problems and they know where to go, at least to address the particular legal issues that he or she may confront. In other words, it's a mutual beneficial situation where a law student is trained to handle a case, and here is an individual facing a legal problem, and he or she has nowhere to go. So the law school clinics will immediately provide at least an immediate answer to his legal problems. All of the activities of law student practitioners under the rule are under a supervising attorney. That's the essence of the revision of 138-A. It is intended to produce practice-ready lawyers, but at the same time, inculcate in the law student the sense of social responsibility.
So, Justice Alex, the resolution of the Supreme Court dated December 18, 1986 has been revised to what extent? Schools are still mandated to have legal education clinics,
Yes, Your Honor.
and you have to be still at least, you should be, you must have finished the third year before you can be a part of that.
Your Honor, as early as your sophomore, you can be in the legal clinic already. There are clinical legal education courses that can be offered and enrolled to by a law student as early as sophomore. So the early introduction of law students to the concept of clinical legal education is there already. No, sir.
Lawyer-client will also be applicable to
Yes.
students in that legal education clinic.
There are restrictions provided for in 138-A that the lawyer-client privileges would apply equally to those law students.
And that also the student in a legal education clinic must be bound by the ethical standards that apply to members of the bar.
Correct, Your Honor.
Okay, thank you. Let's go to law school admission tests. You are of the view that we should do away with these entrance exams or not at all?
No, Your Honor, we are not saying that we should go away with law school admission tests. But we are only saying that law school admission tests should not be conducted by the LEB and the way that they conducted it by way of PhilSat. We are saying that the school should adopt a uniform and standardized law entrance examination that the law schools themselves agreed to administer.
The reason why I'm pointing that out, Justice Alex, is that Article 14, Section 1 mandates that the state shall protect and promote the right of all citizens to quality education at all levels and shall take appropriate steps to make such education accessible to all. I am a provinciano. I finished law in Ateneo, but I took my first 2 years in the Vinewood University, and luckily I was able to pass the entrance exam in Ateneo. My point is, it is very difficult for provincial students to pass entrance exams knowing that their education at the elementary level is not of the same quality as that of the private schools like Ateneo, San Beda, or La Salle in Manila. And even in pre-law, it will really be difficult for students coming from the province to pass entrance exams from both UP or given by both UP, San Beda, and Ateneo. Justice Alex, many times when we were both faculty members of Ateneo, we were given the prerogative or the benefit of recommending to the dean students should be admitted to law school even if they failed the entrance exam. And many times, Justice Alex, I even recall of a certain Calvo, the niece of the wife of Senator Drilon, Violi Calvo. She failed in the entrance exam, but she made good in Ateneo Law and even made it to the Dean's List. And many others, Justice Alex, a lot of those who failed in the entrance exam made good in law school. And you know that the practice we had in Ateneo was this: after one semester or even after 1 year, 2 sections would already be out.
Yes,
And by the time they would reach fourth year, we only have an enlarged section. So my point is, these entrance exams is not really a good policy for law schools to discriminate provincial students who, in the beginning, are really handicapped to pass the entrance exam, but they made good while they were already students in Ateneo Law. Would if a case in this regard will reach the Supreme Court, would you allow handicapped students from the province to be enrolled by a compulsory process in law schools, regardless of the results of their entrance exams?
Precisely, Your Honor, that's the essence of academic freedom. Academic freedom, one of its essences is the school decides who should be admitted to study. The conduct of a law entrance examination should not be the sole basis for a student who wishes to enroll in law school for admission. As you said, in Ateneo, we allow people who did not pass the entrance exam, but based on interview and review of other credentials, they may be allowed to enroll in law school. So what we're saying is that we need to have an entrance exam, but it should not be the sole determinant for purposes of allowing a student to enroll in a law school. This could be an aptitude test to determine at least to what extent the student's capabilities are, but it should not be the sole deciding factor for purposes of admitting a person or a student who wants to enroll in law school. That's the choice. That's the essence of academic freedom. The school decides who should be admitted to study. And they may consider part of the qualifying standards passing an entrance examination. And they may the passing grade or the grades for admission the school may fix it themselves, so that they themselves decide who should really be admitted. That's the
Justice Alex, well, that's a good point. But academic freedom, in my view, must yield to a constitutional mandate. And this is a mandate given us, you, the judiciary, we in Congress, and even the executive department, that the state shall protect and promote the right of all citizens to quality education. Here, the government has failed in this mandate as early as elementary, high school, and even pre-law. And it says at all levels. Again, without this constitutional mandate, I will have no qualms in saying that yes, academic freedom should be unimpeded. But here is a constitutional mandate. What then, as Chief Justice of the Supreme Court, would you do to help students from the province who were handicapped in the beginning, elementary, high school, college, pre-law, in their education, quality education-wise? What, as Chief Justice, will you do to help these provincial students?
Well, Your Honor, if there's no case filed in court, there's not much justice. However, outside of a judicial function, as part of our activity during the summit, we have decided and we have recommended, and some law schools have agreed, that to level the playing field in terms of legal education, we encourage professors from the Metro Manila-based law schools to lecture for free, okay, to those law schools outside of Metro Manila. The host faculty is challenged in the sense that they don't have much professors to teach specific specialized subject, and some deans have signified their willingness that they are willing to travel and give lectures to law students from the other law schools, especially state colleges and universities in far-flung areas of the country. And I think that's the way we can level the playing field with respect to providing a quality legal education to students who are handicapped in some ways, especially those coming from the provinces. And I think with technology now available, then perhaps these law schools can be, we can tap again these law schools if they are willing still to continue the concept that we have agreed upon for law school professors based in Manila law schools to be able to give lectures to law students in the provinces. And I think this is more feasible now in view of the use of technology. They can conduct Zoom sessions to law students from other provinces. And that's the way I think, aside from the judicial function of the court, how the Supreme Court can assist those students in who are, as you said, handicapped in some way of acquiring a good legal education, Your Honor.
But at least, Justice Alex, you are of the view that entrance exam is not a be-all criterion in
Yes,
the taking in of law students.
absolutely agree on that. Not the end of all.
The reason why I'm asking that is that I personally have a problem with CHED. We have already budgeted billions of pesos for free education in college. But CHED came up with a rule that only those who passed the entrance exams can be admitted to state universities and colleges and be allowed to enjoy the free education provided for in the General Appropriations Act. I said, oh my God, in the elementary, well, you were talking about internet, about Zoom. In the 3rd District of Leyte, we rarely have an internet there. In fact, for this purpose, I have to travel to Tacloban in order that I can join this interview because we do not have this facility in the 3rd District of Leyte, Justice Alex. What more can you expect of students in my district? Imagine, I fought for a free education of our children in state universities and colleges, yet rarely can I see a student in my district who would be enrolled in state and colleges in here in Leyte because again of that handicap. With your opinion that entrance exam should not be the be-all criterion in the admission of students to college education, I think I can already appropriately take the necessary steps for this. Thank you, Justice Alex, and good luck.
Thank you very much, Your Honor, for the time that you gave me also. Appreciate it, Your Honor.
Thank you, Congressman Justice Veloso, sir. That concludes the interview for Justice Alex Gismondo. Mr. Justice Gismondo, sir,
Yes.
good luck.
Thank you very much, Attorney Aricheta.
Your Honors, the next for interview will be the Honorable Justice Ramon L. Hernando. Cornelia, please admit Justice Hernando.
Already admitted, Your Honor.
Good afternoon, Justice Hernando. Mr. Justice Hernando, sir, good afternoon. We cannot hear you, sir.
Good afternoon.
Okay.
Hello?
Yes, sir. Good afternoon.
Can you hear me already?
Yes, sir. Loud and clear. May I request you to please rise and raise your right hand so that I can Justice, do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial and Bar Council?
Yes, I do.
So help you God. Thank you, Justice. First to interview the candidate, Your Honors, will be Judge Franklin J. De Monteverde. Judge De Monteverde, sir. Attorney Lea, si Judge De Monteverde.
Okay, thank you, Attorney Ed. Good afternoon, Justice Nando.
Good afternoon, Your Honor.
Yeah, okay. Now, you're only 54 years old.
Yes, I am.
And should you be appointed, you have a long 16 years to be the Chief Justice. Correct?
Yes, Your Honor. As to my age, it's correct.
Yeah, as to your age. Because among the three aspirants for the CJ post, you are the youngest in terms of age, as well as in length of service in the Supreme Court. Now, my question is, will this be an advantage for you? Or shall it be a disadvantage?
It
Let's
is
go first
definitely
with the advantage.
Yes, I think it's definitely an advantage, Your Honor. I'm still young to be able to tackle the very hard work that a Chief Justice has to go through in the Supreme Court, and with supervising the entire judiciary, and also with regard to plans for the court. I think 15 years would be an ideal time for me to be able to finish concrete plans that I would have in mind for the court and the judiciary.
Okay, as I said earlier, if you're appointed, you will have the longest term so far as Chief Justice, and you will be known as one of the longest serving Chief Justices of the contemporary time. Now, how do you envision leading the judiciary through the years, and what will be your goal?
I would like to make reference to my long-term plans for the judiciary, Your Honors, which the council required me to submit. And the very first, and which is on top of my long-term plan, is for the eradication of backlog of cases.
Okay.
I believe that this is a disease that should be eradicated. I'm using the stronger term eradication instead of just elimination because of the gravity of the situation, Your Honor. And if we were to go by statistics of the courts, from the Supreme Court down to the MTCs, there is a consistent failure, not so much because of the lack of dedication by the justices and judges. There is a consistent failure to go up or to step up the number of cases to be disposed every year. In the SC, there is only a 39% disposition rate. In the Court of Appeals, about 40. In the Sandigan Bayan, about 30. In the CDA, the same thing. In the RTCs, Your Honor, they have only about a 43% rate of disposition every year. And surprisingly enough, the MPCs are the ones faring very well because they have the highest number of disposition rate, which is 70%. I think that this failure to be able to at least meet the ratio of 1:1, meaning to say for every case that comes in, a case should be decided at the end of the year, is due to a number of factors, Your Honors. And there are at present some measures being implemented by the court. For instance, the continuous trial of civil and criminal cases, which has shown some promise, Your Honor. And there should also be strict monitoring and evaluation of court processes and decision-making processes, Your Honors. On top of this, I think there should be an adoption of a harmonious or coordinative partnership with all the stakeholders in the judiciary. I'm referring to the 5 pillars of our justice system, Your Honor. I think that we should coordinate with the DOJ, their prosecutors. We should coordinate with the Public Attorney's Office with respect to their defenders. And we should not forget the legal practitioners, because they are also the ones who get to appear in court every day in and day out. So that's one of my primary goals, Your Honor, eradication of case backlog.
What's your second long-term goal?
The second, Your Honor, I think is just as important. It is the establishment of vital infrastructure in the judiciary. And when I'm referring to infrastructure, this would include land banking and construction of halls of justice all over the country, Your Honor. What I mean by land banking is that there is a need for our courts to be housed separately from the LGUs and other offices of government. A classic example of a city that needs a land for itself as to its hall of justice is the city of Manila, Your Honor. For the longest time, our courts have been housed in the City Hall of Manila, and we all know about all the problems that they have there. The Hall of Justice of Manila has been subject to years of groundbreaking. It has never even been started, the construction, I mean. And in 1993, when I was a young lawyer in the Supreme Court, I remember very well that there was a groundbreaking for the construction of the Hall of Justice of Manila. It is now 30 years later and still no Hall of Justice for the city of Manila. So I think we need to get lots for our halls of justice, separate ones. We need to have halls of justice that would stand as a testament to our courts, fealty to the administration of justice. And we need all this, Your Honor, on top of just eradication. We need these facilities so that we can also come up with a very efficient administration of justice.
Yeah, your third goal, long-term goal, calls for the strengthening of an anti-corruption measure, or rather strengthening the anti-corruption measures. How would you go about it?
Yes, Your Honor. Just last year, we came up with the Judicial Integrity Board. And it is for the very first time in our court's history that we have this an internal affairs office. The office has the function and duty of investigating corrupt practices and the like committed by justices, by judges, and even court personnel. It is a very new office within the court, Your Honor, and it's just starting its steps. And I would hope that if I would be on top of the court, that I would be able to strengthen the JIB in the years to come by giving it proper office. They don't have an office at the moment, Your Honor. That befits them. Personnel would be needed by them. They have yet to come up with a definite plantilla. We have approved a plantilla for them, but they're just starting with the employment of or hiring of their plantilla.
Okay.
So we need also to strengthen the JIB.
Now, you mean to say, Justice Hernando, that henceforth, all complaints against justices, judges, and court personnel will be directly filed with the JIB and no longer with the OCA.
That is accurate, Your Honor. Except that for pending cases at the moment, the OCA will just finish this, and then eventually this will be transmitted to the JIB for appropriate action.
Okay. Now your legal...
But
okay, go ahead, Justice.
But the JIB has no jurisdiction over Supreme Court justices, Your
Yes,
Honor.
yes.
Except for
Now, what's your fourth long-term goal?
in the field of both legal and judicial education, Your Honor.
And how would you implement this fourth long-term goal of yours?
I would wish to institutionalize bar examination reforms that are underway. This year, we will have for the very first time a digital bar exam, Your Honor. Examinees will use their laptops to answer the questions in the bar. And this will, I think in many ways, level the playing field, because those who have, for instance, those who have very poor penmanships would no longer have to worry about that. And moreover, it will make faster the submission of answers to the examiners who can immediately correct the answers. And also, Your Honor, there is the matter of regionalization of the bar exam. That's going also to happen this year. There will be venues in Luzon, in Visayas, and in Mindanao. And this will help our bar examinees from the provinces who will no longer have to spend that much in reviewing for the bar and even in the matter of coming to Manila for the bar examinations.
So the regionalization of the bar centers will commence.
Yes, Your Honor.
Here's exam board.
Yes, Your Honor.
Okay. Now let's go to your short-term plans, one of which is number 4, the review of the plantilla of the entire judiciary. Fill us on this, please.
Yes, Your Honor. Thank you. I'm currently the vice chairperson of the Committee on Plantilla in the Supreme Court, Your Honor. And in the course of our review of the plantilla in the different courts, from the Supreme Court down to the first level courts, we have found out that there are positions in their respective plantillas that are distorted, meaning to say, and I can cite as an example the clerks of court in the first level courts. In the Metro TCs, a clerk of court has a salary grade of, I think, 22, whereas in the municipal trial court, it's, I think, 15. And then in the MCTCs and municipal circuit trial courts, the same thing, Your Honor. But these clerks of court are doing the same thing, basically. And so there is a case of poor morale with respect to the clerks of court of the MTCs who have lower salary grades, because they see their counterparts in the Metro TCs having a salary grade that is much higher. And a salary grade that is much higher would mean more benefits for them. And so the low morale, Your Honor. And it's not just in the MCTCs, the MTCs, that this is happening. It's happening in the CA, it's happening in the Sandigan Bayan, and even in our own backyard in the Supreme Court, Your Honor. Our clerks of court have varying SGs. Surprisingly enough, this should not have happened because this is the Supreme Court, but then there is a problem. And so we need to rationalize our plantilla, the entire plantilla for the judiciary, so that there will be equalization of positions, equalization of salaries, equalization of benefits, and the like.
Isn't it a fact that the problem with the clerks of court are the same with the judges in the Like in the provinces and the MCTC, MTC, they're practically the same, but some judges there, especially in the far-flung areas, have a very low docket, and yet they are receiving the same salary as the others who have high dockets.
That's true, Your
That's
Honor.
correct. You know, how will you go about evening the playing field?
That may need some review, Your Honor, because the location of a station may is such that there would be very few cases. For instance, the population is so much less than the ones that are located in cities. So we will need to review that, Your Honor. But we have to have a plantilla that is equal across the board, Your Honor.
Correct.
Because our civil service, in fact, requires that. Our Constitution requires that there be equal positions in all salary grades or steps in the government.
Okay. Now, Justice Hernando, should you be appointed as the Chief Justice, are you going to be a liberal or a conservative Chief Justice in terms of handling the court administratively and in terms of deciding cases?
Your Honor, in terms of deciding cases, and I think you're referring to my judicial philosophy. At the start of my career, I adhered to the textual approach with respect to interpretation of the Constitution. But as I have aged in the court, I have come to realize that I am actually an originalist, one who adheres to the wordings of the court as the founding Constitutional Commission members had intended the fundamental law to be. And so that would call for, in many ways, restraint. If I were, therefore, to interpret a statute passed upon by Congress and signed by the President, I would adhere to judicial restraint, Your Honor. And what I mean by that is that I would extend a becoming respect for acts of Congress and for acts of the President.
Okay.
On the administrative side, Your Honor, I've come to know myself. I have a soft side in that I am a consensus builder. I do not impose myself on people, my views, my opinions. Instead, I try to understand what their views are. And by understanding what their views are, I think it would be better to get an action that is most appropriate for everyone. So I would be a consensus builder and someone who leads by diplomacy, Your Honor.
Okay. Being the youngest, being one of the youngest, if not the youngest justice, associate justice to be appointed as Chief Justice, do you think you have the moral ascendancy over the others justices in the Supreme Court?
I would believe so, Your Honor. Most of my colleagues in court have been colleagues in the appellate court. In fact, a third of us are already in the High Court, Your Honor. I've known them for most of my life in the appellate level, and I don't see any real problem or complication when it comes to getting a consensus from them. In my experience going through the ladder in the judiciary, Your Honor, I sometimes felt like Jesus among the elders, and it has come about in a very positive way because My experience is that those who are older than me have treated me very fairly and with respect, notwithstanding my age.
Okay, Justice Hernando, in your letter dated March 11, 2021, wherein you submitted your long-term and short-term plans for the judiciary, you made mention also of an opposition of Attorney Philip Furado, formerly the Government Corporate Counsel, saying that you opt not to answer or comment to the opposition, but you will answer the matters raised therein during the interview.
Yes, Your Honor.
What is this all about?
Your Honor, the oppositor, as you know, was dismissed as OGCC chief by the President about 2 years ago.
Okay.
For coming up with a legal opinion concerning the Aurora Pacific Economic Zone Freeport, or APECO, where he opined that APECO can grant licenses for online gaming even beyond its jurisdiction. And that resulted in encroachment on the authority and power of PACBORD. Because of that, the President dismissed him, Your Honor.
Yeah.
And he somehow tied his opposition to the fact that my wife had been part of OGCC.
Your wife was connected with the OGCC?
Yes, Your Honor. She was a government corporate attorney, but she has since left OGCC 2 years ago.
2 years ago, that was in 2018 or 19?
19, Your Honor, April 2019.
So I was still there, sa MWSS.
Yes, Your Honor. That's
yeah. I was the chairman of the MWSS at that time.
Yes, Your Honor.
Oh.
And in the OGCC, the corporate lawyers or attorneys of the government are given allowances by all the corporations of the government that they handle. And the oppositor, when he stepped in as OGCC head, prohibited the government corporate lawyers from receiving the allowances on the ground that COA had disallowed it. My understanding is that there is a legal question involved with respect to their receiving of these allowances, Your Honor. Anyhow, my wife left OGCC in that state. They were still receiving allowances. And with respect to the oppositor, Your Honor, the chief, I think the subsequent chief of the OGCC and other members, high-ranking government corporate lawyers, filed a disbarment case against him in the Supreme Court for coming up with that APECO opinion. And that fell to Justice Henry John Paul Inting in the Second Division, to which I belonged at the time. And the Second Division, after deliberating on the disbarment complaint, felt that the oppositor had come up with a legally unacceptable view. He should not have done that, issuing the opinion, because APECO was able to gain financial interest from its online gaming operations outside of its jurisdiction, Your Honor. And that resulted in prejudice to government. So we felt that he should at least be reprimanded. So he was reprimanded. And oppositor is now tying it up to the fact that he had prohibited my wife from receiving allowances. And therefore is now saying that I lack, in so many words, delicadeza for participating in the disbarment case against him. But let me point out, Your Honor, that in the verification and certification against forum shopping in his opposition, he expressly admitted that the Second Division case is not related in any way to his opposition. So I leave it at that, Your Honor.
Okay, Justice. A few more questions before I leave. No? Now, a group of law academicians justify their legal standing by saying that the law's threat to freedom of speech affects them as educators who want to teach their students that dissent and activism are part of democracy. With the Anti-Terrorism Act of 2020, these can now be interpreted by the government as constituting terrorism, said the professors in their petition. Question: is this not an intrusion to academic freedom? Kindly explain.
Your Honor, if I may respectfully decline giving an answer.
Yeah, it's pending.
If I may decline, Your Honor, because we are currently hearing the
Okay.
law. We're still conducting oral arguments, Your Honor.
Okay, Justice, I understand.
I apologize.
How about this encounter between the PNP and the PDEA? No case yet, no?
As far as I know, there is no case yet filed in court.
Okay. Now here's the question. A cell bust could have caused the botched anti-drug operation that led to the deadly shooting between the PNP and the PDEA near Evergotesco Mall. Someone has to answer for this, whoever conducted the cell bust. Danao said in a mix of English and Filipino. Now, what is this cell bust in the law books? Is it included in the cell books, in the law books? Cell bust. This is, I think, opposite by bust.
Yes, Your Honor.
That's a new term, no?
It's a new concept for me, Your Honor. In jurisprudence, all we read about are by bust operations.
Okay. Now, discuss its legality, if you may. Is it illegal or legal? Your own opinion.
I think it's entrapment, Your Honor. In many ways, a law enforcer would sell an illicit drug to a suspected peddler, and so he catches him in pari delito. That's probably the closest that I could get to characterizing what a cell bust is.
There's a new lingo, huh?
Yes, sir.
Okay, my last question. After defending democracy in EDSA exactly 35 years ago, the Catholic Church now needs to help deepen the Philippines' gains from the People Power Revolution of 1986. An expert said, defending is just a first step. Deepening is a different story, and that is the challenge to our church these days, said Arjan Aguirre, political science professor from the Ateneo de Manila University. This can be seen in how the Catholic Church has been very vocal on different political and social issues, denouncing the Duterte government's war on drugs, the hero's burial for the late dictator Ferdinand Marcos, and the passage of the controversial anti-terror law. Question: what is your stand on this when it is clear that there is a separation of the church and state?
Insofar as our fundamental law is worded, Your Honor, it is true that there is a separation between church and state.
Okay.
I would think that with regard to matters that are within the concerns of the church, which I would say would include alleviation of poverty, respect for the rights and dignity of individuals. I think that the church can speak on these matters,
Yes.
but insofar where their concerns would already encroach on policies of the executive and the legislative and even the Supreme Court, the judiciary, I think that they would have to push back a little. They would have to leave to government the matter of how these concerns should be addressed and solved. And ultimately, I think, Your Honor, that there would be a cohesion in respect of the relations between church and state if there would be respect for the respective concerns. I don't think that the church can arrogate unto itself the position of being able to view with a very definitive lens that government is wrong on a particular aspect. I think it's for government also to impress upon the people that it is after their welfare that it is doing these actions. And so I think that there is a need for respect for these institutions when it comes to the lives of our fellow men.
Okay, thank you, Justice Hernando. That was my last questions, and good luck.
Thank you, sir.
Okay.
Thank you. Thank you, Judge.
Oh. Sige.
The next to interview the candidate will be the Honorable Justice Noel Jimenez Tiham. Justice Tiham, sir.
Thank you, Attorney Arecheta. Good afternoon, Attorney Justice Mon.
Good afternoon, sir.
By the time you retire from the High Court, I will be almost 90 years old.
You said so, Your Honor, during your retirement.
Do you think it will be easy to get a consensus from the bank where the members are older than you are if you are a Chief Justice? How do you describe your interpersonal relationship right now with the members of the court?
It's very collegial, Your Honor. An ate calls me Bunso every time she sees me, Justice Ami Javier. And I would have to say that since all of them are my manongs and manangs in our Filipino culture, the Bunso is supposed to be spoiled. And I would hope that they would spoil me more with, or by way of giving into what my views would be on certain cases and the like.
The good thing about the good thing about time and the fact that you still have, if you become Chief Justice, you still have 16 years to go in the judiciaries, you can do a lot of things. But the downside of time is you can take your time and delay the implementation of the good things you are thinking about to do. Is it possible you might get bored staying in the judiciary for 16 years?
If I may say so, Your Honor.
The job in the Supreme Court is very, very taxing. And to become a Chief Justice, it's an enormous responsibility. You might grow older faster by becoming a Chief Justice. So what are your thoughts on that?
Your Honor, if I may say so, I am a child of this institution. I started my professional life here way back in 1991, right after taking the bar exams in 1991. I got hired by Justice Edgardo L. Paras. And it was in this court that I got to know the results of my bar exam. And so this institution is an institution that I really revere, Your Honor. I've been in government all my life. I've never strayed.
You've been a prosecutor, you've been an RTC judge, a Court of Appeals justice, and now a Supreme Court justice. Now, let me just say, the past chief justices implemented many reforms. Are there still reforms that need to be done, despite the fact that the past chief justices have implemented many reforms?
Definitely, Your Honor.
Were they less imaginative than you are, do you think?
Not really, Your Honor. I was looking at the 5-year point program of former Chief Justice Davide from 2001 to 2006. Very comprehensive approach to reforms in the judiciary. Some of the reforms that he wanted to implement obviously could not be done because of his retirement and also the passage of time, Your Honor. I think that there are still, or there will always be reforms that have to be adopted and implemented in any kind of organization, and that includes the judiciary, Your Honor.
Now, let's talk about the backlog of cases. There are still many pending cases in the courts, not because the magistrates and judges are lazy, but because there are so many cases filed by lawyers and litigants. And do you value precedents, Justice Mon? Jurisprudence?
I do, Your Honor, stare decisis.
How come lawyers and litigants, despite reading jurisprudence, despite knowing the decisions of the Supreme Court, repeatedly file petitions? The same or similar petitions that have already been decided in a particular way based on precedents. Isn't it about time that we educate lawyers and litigants about the principle? By the way, the principle of the Supreme Court being the court of last resort, does it have a constitutional mooring or basis? Or is that just a jurisprudential statement?
Well, our Constitution places the Supreme Court at the apex of the judiciary, Your Honor.
But does it mean that all cases should go up to the Supreme Court and no decision can be respected, no decision can be accepted as binding, not until the Supreme Court has placed its imprimatur on the decision? That seems to be the impression created in the minds of the public.
Yes, Your Honor. Not all cases. I would definitely say that only cases of, to use the term of the court itself or the phrase, transcendental importance should go to the High Court.
Even if it is of transcendental importance, if it involves factual issues, it's not supposed to be the Supreme Court. Now, my question is, as one of the reforms in the judiciary, will you amend the rules to authorize trial court judges to dismiss outright cases, petitions, which are baseless and without merit?
Definitely, Your Honor. I think we are doing that also in the Supreme Court and in my experience in the Court of Appeals, Your Honor. If there should be...
The first level court judges are afraid to be sued or to be the recipient of an administrative complaint if they are bold enough to dismiss cases which are unmeritorious.
I agree with you, Your Honor. I think our judges at the first level and second level courts should be really educated that they can do, in fact, dismiss cases outright. if they are not meritorious from the outset.
Because if the public is of the opinion that the Supreme Court, being the court of last resort, has the final say, isn't it practical to just abolish all of the courts and just have one Supreme Court consisting of 4,000 justices spread all over the country, and any decision they make will become final? That seems to be the impression of the public. Now, let me talk about corruption. Why do you think, in your opinion, why is there corruption in the judiciary? Is it because we do not train ethical lawyers, but rather we train competent lawyers?
I agree with you, Your Honor. I think there is a lack of emphasis on training on the ethical side. Even in law school, not too much emphasis is given to legal ethics. And I would really think that we need to educate our lawyers on both fronts. I think it's even more important to educate our lawyers when it comes to ethical matters.
Now, this is
our judges.
This is a public interview. You're talking to the public because the public is watching. How would you explain to a layman who is not a lawyer the concept of judicial independence? You're now talking to the public. What is your opinion? What is your understanding of judicial independence in layman's terms?
If I may be permitted to speak in Tagalog,
Go ahead.
ang akin pong sasabihin sa kanila ay ang ating mga korte ay hindi dapat nababahid sa korupsyon dahil isa itong institution na hindi or dapat pananagutan ang pagiging patas. At yung pagiging independent ay isang elemento ng magandang administrasyon ng hustisya. Ang ibig sabihin po nito ay ang isang huwes ay dapat umakto at humusga ng isang tao o ng isang kaso nang walang impluwensya sa labas, kundi base lamang sa ebidensya at kung paano niya ito nakikita.
And you will be a Chief Justice and you will practice judicial independence. Do you have any qualms, any reservations against ruling against the President who will appoint the Chief Justice?
I have no such qualms whatsoever, Your Honor. My fealty would be to the Constitution and not to the appointing authority.
Now, as an aspirant to the position of Chief Justice, in your opinion, in deciding cases before the High Court, in the en banc, for example, should the court take into consideration in deliberating and drafting the decision the possible effect of the verdict upon, let's say, political stability or the economic welfare of the country?
If the case should involve, for example, economic matters, Your Honor, and if it's a legislation that is being questioned before the court, then by virtue of my judicial philosophy of restraint and of giving respect for the act of Congress, then I would have to rule on the basis of the policy as set out by Congress in coming up with the statute.
In your ponencia, Justice Mon, in Manila Water Services versus DNR, you are a judicial maverick when you impose a fine of 1 billion pesos, this is against Manila Water, correct?
Yes, Your Honor. And Maynila.
Yes, but the amount of the fine, was it based on empirical data?
No, Your Honor. It's based on the Clean Water Act. What
But the amount itself, how did you arrive at 1 billion? Was there a mathematical computation? Was there
Yes,
data?
Yes, Your Honor. It's in the footnote of my ponentia.
Now,
One of the last footnotes.
Who benefited? Who received the amount of 1 billion fine?
Well, so far it has.
A way of giving it back to the public?
No, Your Honor. I think the money will go to the treasury of the government.
To the government. All right.
Yes, Your Honor.
You also decided the case of People versus Maria Cristina and Sergio Lacanilao. This is the famous case involving Mary Jane, where you allowed the taking of her deposition.
Yes, Your Honor.
In your ponentia, in the case of the letter of Mrs. Corona, requesting the grant of retirement and other benefits for the late former Chief Justice Renato Corona, and for survivorship pension, the court ruled in favor of the family, Mrs. Corona and the family, that despite the impeachment proceedings, the court ruled that what was merely divested was his political capacity as Chief Justice, that there is no legally actionable liability, that there was no conviction, no judicial conviction, correct?
Yes, Your Honor.
And therefore, the penalty was only removal from office. Parenthetically, only for purposes of academic discussion. Can you apply the instant case to the case of Maria Lourdes Serrano? For academic discussion, so that law students can discuss it. Assuming that Justice Serrano is entitled to retirement benefits, would you have granted retirement benefits to Justice Serrano?
Your Honor, the manner in which the former Chief Justice was removed was via quo warranto.
So
And that's judicial.
There's no identity.
That was judicial, Your Honor. And by virtue of your ponentia, in fact, she was divested of entitlement to retirement benefits.
So she was removed as Chief Justice, correct?
Yes, yes,
but
Your Honor.
she cannot go back to a vacant position as Justice because there is no vacant position as Justice. So she had to leave office. Now, let me ask you about your dissent in the matter of investigation report of the alleged extortion activities of a certain judge who died, correct? So
Yes.
the majority ruled that there is no administrative liability anymore, correct?
Yes,
Because
Your Honor.
the judge has died. What was the basis of your testimony? You said that you can still proceed against the judge?
No more, Your Honor.
No more, okay.
The case should be dismissed because he has died.
I
My
see.
dissent there, Your Honor, has become the majority. In the motion for reconsideration,
I
by
see.
a vote of 10-4, my dissent became the majority.
So the ruling now is a judge who is facing an administrative complaint and who dies during dependency will not be meted any penalty, even a fine or forfeiture of benefits. That is now the rule.
Yes,
Because
Your Honor.
in the past, fines were still
Yes.
imposed by the court.
Yes, Your Honor. By virtue of the ruling on the motion for reconsideration in the case of Judge Godofredo Abul, that's the Abul case, Your Honor, a judge who is facing administrative cases at the time of his death.
You did mention his name. You mentioned his name.
The former prior jurisprudence had been anchored on the basis that had the judge not died, then he would have been meted the penalty appropriate, Your Honor. But in my dissenting,
but in the past, fines were still being imposed.
yes, Your Honor.
Forfeiture benefits, correct?
Yes, Your Honor. But in my view, in the dissenting that eventually became the majority, a dismissal is similar to the penalty of dismissal is similar to a penalty imposed in a criminal case. So that if an accused dies during dependency of his case or even on appeal, it should be dismissed. Then we should also extend the same logic to administrative cases, Your Honor.
All right. My last question is: you concurred in the ponencia of Justice Marvick in the case of Alanis versus Court of Appeals.
That's right, Your Honor.
The court allowed the legitimate child to use the surname of the mother because there was a justifiable reason. All right, because it is also in consonance with the prior decision of the court. But the ponente proceeded to discuss gender equality when it was not the issue at all. Isn't it that this is obiter?
No, Your Honor. I think it also goes into the ratio because it involves also the right of a mother to have her surname used in perpetuity.
Is this now a blanket authority? People who have been reading it in the newspapers, is this now a blanket authority for a legitimate child to exercise the choice whether to follow the surname of the father or the surname of the mother?
The court
way that a wife can choose to follow the surname of the husband or to follow her own surname. Is that now the ruling of the court?
Your Honor, the court did not say that there will be blanket authority on the part of the legitimate child choosing to use the surname of the mother. In the case of Alanis, the child had been single-handedly raised by the mother.
Yes,
And-
but that justification is not gender equality, but the sacrifice, isn't it? There was
Yes.
a justifiable reason. It was the sacrifice rendered by the mother who who brought up the child, the legitimate child.
That is correct, Your Honor.
Was Justice Marvick carving a possible jurisprudence in the future on gender equality? Because there's now a pending bill in the United States on gender equality. I don't know if it has been enacted into law, wherein they will practically erase gender identification, wherein even transgender can participate in sports activities involving females, things like that. Supposing a similar case is brought before, supposing a law is enacted by Congress in the Philippines on gender equality, erasing that demarcation line between male and female and its ramifications. For academic discussion, would you consider that constitutional or unconstitutional?
I would think that there would be some constitutional bars to that statute gaining validation before the courts, Your Honor. I can cite the case of
One last question, because I forgot. Somebody texted me. in a case, hypothetically, in a case involving the war against drugs by the government and the constitutional duty of the court to protect constitutional rights, what constitutional issues will you look into? So this is hypothetical. This is purely for academic discussion. This has no reference to an actual case. Hypothetically, the war on drugs by the government. Now, vis-a-vis the duty of the Supreme Court to protect constitutional rights, what constitutional issues, if you are the ponente, what constitutional issues will you look into?
One would be unlawful searches and seizures, Your Honor. In many of the drug cases that have come up to the Supreme Court for review, a number of those cases have involved searches and seizures of drugs, whether in pari delicto or by virtue of bypass operations. So that would be one matter into which the court can look into. Another would be respect for the rights of the accused who have been apprehended by the law enforcers, whether they have been extended the right to counsel, the right to be informed of the nature of the case against them, etc., etc.
If there is no Bill of Rights in the Constitution, hypothetically, if there is no Bill of Rights in the Constitution, can the High Court still protect the rights of citizens in a country?
I would think so, Your Honor. We can look into the preamble and the whereas clauses of the Constitution, where the Constitution itself lays down one of the fundamental obligations of the state to give respect to the rights of citizens.
Or the limitation of abuse of power of government.
That's also one thing, Your Honor.
All right. Thank you very much, Justice Mon. Don't forget to invite me when you retire 16 years from now.
Yeah. Thank you, Your Honor.
Thank you. Thank you, Justice Tiam. The next to interview the candidate will be the Honorable Judge Toribio Ilaw Jr.
All right, thank you, Attorney Aricheta. We're tired. Yes, good afternoon, Justice Mon.
Good afternoon, sir.
Still look fresh because you're still young. All right, what are your thoughts on the rule of seniority in the judiciary in general?
It's a stabilizing tradition, Your Honor, and practice. Seniority is based on not really on the age of the justice or judge. It is based on the date of appointment. I think it's one peculiar feature that attends members of the bench. They get to have ascendancy with respect to privileges and other matters relating to protocol on the basis of their seniority and appointment. I think it's one tradition in almost all courts everywhere, not just in the Philippines, Your Honor. In the US, in European countries, seniority is a bedrock as to how courts function. So that's my thinking on seniority, Your Honor. So I think it's an essential facet of the judiciary.
Simply for stability. That's the reason why we have these rules. In case of promotion in the judiciary, if you are in the first level court, to gain such lateral transfer, you must stay in the present position for at least 3 years. And with respect to promotion to the second level court, you must have at least 5 years and more than 5 years in the appellate courts. All right, here's a question coming from a co-veteran of yours, retired Justice Sir Reyes. Is length of service a significant consideration for the Chief Justice position?
It should be, Your Honor, but it should not be the determinant, or I mean the primordial consideration. There has to be an assessment also of the entire character of the individual for that purpose, Your Honor.
All right, here's a query from another concerned person. Whether or not it is lawful for a law school to prohibit fraternities?
It is lawful for law schools to prohibit fraternities, Your Honor, if these associations have for their policies admission by way of violence, doing violence before getting admitted to the organization. But if it is a fraternity that is engaged in purely academic purposes, then I would think that there is no basis for law schools to bar these fraternities.
As far as you know, can you name law schools which prohibit fraternities?
Our law school, Your Honor, San Beda, now prohibits fraternities.
Fraternities, about sororities. They allow sororities.
I'm not sure about sororities, Your Honor, but I'm very sure that they now prohibit fraternities.
All right. There is a pending case with the United States Supreme Court, which involves the right to the free exercise of religion. So to curb the effects of COVID, New York Governor Cuomo issued an order limiting the attendance at worship services. However, certain businesses which are deemed as essential were allowed to operate. The Roman Catholic Church of Brooklyn and two Orthodox Jewish synagogues sued to enjoin the implementation of the governor's order, as it violates the right to free exercise of religion. They likewise question the imposition of said restriction when in fact, and I quote, essential businesses remained operational. If you were the ponente of this case, how would you decide? This is an American case.
I would think, Your Honor, that that measure of the governor of New York would be in the nature of an exercise of police power, because it would be the existence of life itself that would need to be protected. It's a health concern that is not just local but global. And I think that in all respects, it concerns a proper exercise of police power. So I would go for validating the act of the governor of New York on that basis, Your Honor.
All right, one of your long-term plans is the adoption of harmonious or coordinate partnership with public prosecutors, public defenders from public attorney's office, and law practitioners. Could you explain this further in brief?
Yes, Your Honor. I would like to relate it to my long-term plan for judicial education. In one of my proposed plans for the long term, I would wish to have the Charter of PhilJA reviewed and possibly for it to be converted into an institution of higher learning. And it will not only cater to judges and justices, but also prosecutors, public defenders, and even legal practitioners. And I think that if that happens, then it would result in a very cohesive justice system, because then we would have judges who are familiar with how prosecutors work. We would have prosecutors who would be familiar with how judges work. We would have defenders from the PAL who would get to acclimatize and also get to be familiar with how our judges and prosecutors work. And lastly, we would have law practitioners who would get to know our judges, how they work, who would get to know our prosecutors, how they prosecute, and would get to know defenders from the public office on how they would be advocates for the administration of justice. So that would be one way of adopting a harmonious and coordinative partnership with all the stakeholders in our criminal justice system.
You mentioned about legal education and being also a professor of law. You stated that you intend to review the possibility of reducing the law course to 3 years. What made you say so?
Your Honor, a senior year in law school is devoted to review classes only. And the law students have practically studied, and I'm very sure have taken to heart all that they have studied from first year to third year. And I think that we can do away already with review classes for a year. They can review for 6 months after finishing 2 years of studies, and then take the bar after 6 months. So that would also be very beneficial to them, because it would cut on costs for your education. And even with the advent, and now with the advent of the K-12, Your Honor, we're going to see law graduates who would be in their late 20s. And that's close to middle age already, Your Honor, if I may. Sayang naman po yung 1 year. After 3 years, I think they could take the bar exam already and devote, let's say, 1 year of masteran to further their studies and their knowledge. I think it's doable, Your Honor, given the current setup that we have, wherein 4th year is only for review.
That's in reverse, because some other schools are offering this JD, Juris Doctor, 5 years.
No, Your Honor. I think that's the executive type of class that some schools offer for working students. Basically, it's still 4 years. The thesis, the JD course, the thesis gets to be finished in the 3rd year. That's my understanding, Your Honor.
Do you think that some law subjects offered to students are unnecessary?
Yes, Your Honor.
Or to be, to say the least useful? Can you say subjects which are unnecessary?
I can cite the NIL, Negotiable Instruments Law. The NIL is a very old statute, Your Honor, more than 100 years old, I think, and most of its provisions have become outdated. And with our current commercial transactions and structure in commerce, I think that the NIL has lost its significance in law school. It should not even be a subject anymore in the bar exam, Your Honor.
All right, when asked by Justice Tiham regarding your philosophy on judicial conduct, you mentioned a case when you state name the respondent judge, wherein the Supreme Court upheld the forfeiture of the respondent judge's benefits, notwithstanding his death during dependency of the administrative case filed against him, citing the case of Gonzalez versus Escalona. And you wrote a strong dissenting opinion, which you claim to be became the majority decision, stating essentially that the doctrine in Gonzalez must be overturned. Thus, death of the respondent warrants the dismissal of the administrative case. Do you think that the abandonment of Gonzalez doctrine would not deter judges from committing misconduct?
No, Your Honor. The basis for the court in ruling that a judge who dies during dependency of his case would have to, or I mean his case would have to be dismissed, is on the basis of fairness and the fact that, and logic, Your Honor, simply because that judge has died, there is no more judge to whom any fine can be imposed. And I remember very well during our deliberations on the case, Your Honor, I even invoked the fact that it is very unchristian for the court to impose a fine on a person, on a judge who has died. So eventually it became the majority, Your Honor.
And among others, you maintain that the presumption of innocence must apply by analogy in administrative cases.
Yes, Your Honor.
Thus, the respondent's judge death preceded the promulgation of judgment. He should be presumed innocent until the contrary is proven. Do you think that applying such presumption would effectively amend the constitutional provision which states that, and I quote, in criminal prosecutions, the accused shall be presumed innocent until is proved?
It does not, Your Honor.
It's the other way around.
No, I mean to say, Your Honor, that there is a bundle of jurisprudence that supports the present ruling. Presumption of innocence also applies to administrative cases, Your Honor. And that was the basis for my invocation of the presumption of innocence in my ponencia.
All right. In a lecture which you delivered before UST college students, you stated that, and I quote, truth is the ultimate sum of what it is. Without truth, justice is only a perversion of what it should be. The world without truth does not exist. That the world exists at all is proof that truth is at its is. Do you believe that truth is absolute?
It is relative, Your Honor. It's dependent on many factors and perspectives. We get to form a notion of what truth is on the basis of our personal experiences with everyone, with our family, with our friends, with our colleagues, and therefore our notion of truth may be far different from what others would perceive it to be. But at the end of it all, I think that truth is something that is inherent in every individual. I mean, the recognition thereof. A person who is steeped in, let's say, Christian teachings would have a firm opinion of what truth is. And because of that, he would have to live by those principles, Your Honor. So it's something that's relative and not necessarily absolute, as you said it is.
Right. In the same lecture, you were quoted saying, "Be guided by truth amid broken justice system." What exactly do you mean by broken justice system?
A justice system where backlog is grievous, Your Honor. A justice system where access to courts is a big complication for those who are poor. A justice system where there is a perception of corruption. That's what I meant by a broken justice system when I gave that lecture, Your Honor.
How important is a good working environment, Justice?
It is, I think in that respect, I would have to say it is absolutely important, Your Honor.
And
it is
how do
only,
you... Yes, please continue, sorry.
yes, Your Honor. A good working environment has to be characterized by horizontal relationships, Your Honor, and thinkings. In my work in the court, from the time I joined the RTC to the CA to the Supreme Court, I've always looked at the judiciary as a rectangle, not a diamond, or I mean a pyramid in which there is a hierarchy. I think it is very important in any organization that the members of that organization must be able to have very good interpersonal relations with one another and to have a thinking that is horizontal, not vertical, Your Honor. Because it is only by way of a horizontal thinking that there can be a cohesion of that organization. So that's how I look at it, Your Honor.
Rita, what is your reputation among your staff? What does they say about you behind your back?
I'm very caring. I'm very. That would be self-serving, Your Honor, but I can honestly say that I am very caring towards them.
Arat, you explain or your side with respect to the opposition filed by a certain attorney Rudolph Corrado against you, alleging that you lack integrity, probity, and fidelity to sound moral and ethical standards. When you consciously participated in an admin case from which you should have voluntarily inhibited them. Could you tell us an instance where you demonstrated fidelity to sound moral and ethical standards?
Your Honor, I have inhibited on a number of occasions when I was in the second level court where a lawyer had been a classmate, and whose son is my inaanak. And I divulged in open court that circumstance, and on that basis, I announced my inhibition. That's one instance, Your Honor. And I cannot name the number of times where I have refused approaches from lawyers to decide a case in their favor. because I've always firmly stood my ground when it comes to living by what I believe in, and that is that I should be very morally upright because that is what my parents trained me to be.
All right, if appointed, you will have 15 years to serve as Chief Justice. Do you think that such length of time in service would increase or decrease the level of disagreement among associate justices?
It may come, I mean, it may result either way, Your Honor, given the nature of the bank, how it works, where there is always a welter of different views with respect to one particular case. It would all come down to collegiality and a respect for what the others think. I think it is only where there is an express and deliberate attempt at consensus building that any kind of dissension or friction would be reduced or even altogether be dissipated among the members, Your Honor.
All right, last two questions, Justice. If appointed, you will be the chairperson of the Judicial and Bar Council. How will you lead the council?
Your Honor, I would, well, at the moment, the council has or is in the stage where it is institutionalizing reforms with respect to recruitment. I'm very sure that there will come a time when these policies would get outdated or even would need to be revised, therefore. So I would definitely look into improving recruitment policies of the council, Your Honor. And that may be in the way of looking at the educational attainment of an aspirant to the bench. If, let's say, he has a master's degree in law, I think he should be given merit for that, even if he should have less experience in practice. If a particular aspirant has very impressive academic credentials, then he should also be given merit for that, and things like that, Your Honor. I would look into recruitment of the best and the brightest so that the courts can properly function as a true instrument of justice.
All right, my last question, Justice. What can travel around the world while staying in a corner?
May I request for you to repeat, Your Honor? I didn't get it. I'm sorry.
What can travel around the world while staying in a corner?
The internet, Your Honor.
The internet.
Yes.
About the stamp in a letter. Thank you. That was my last question. Thank you.
Thank you, Your Honor.
Was tired. And good luck, Justice Mon.
Thank you, Your Honor.
Thank you, Judge Ilo. The next to interview the candidate will be the Honorable Justice Jose Catral Mendoza. Justice Mendoza, sir.
Good afternoon, Justice. The areas I wanted to cover were already covered by my colleagues. So anyway, I represent the retired justices of the Supreme Court, and they have forwarded questions for you to answer. Anyway, some of them were already covered by my colleagues also. But I'll go to the first, the question posed by Justice Hardelesa on whether the period to decide or resolve a case should be in the Supreme Court should be mandatory or directly. What is your opinion?
Based on my reading of the Constitution itself, Your Honor, the relevant provision, I think that requirement is mandatory. There is usage of the word must, and in fact, there is even mention of the word mandatory period. So it's mandatory, Your Honor. But I would also think that these are not really self-executing provisions. There would have to be implementing regulations, so to speak, that the court would have to come up with. In fact, the court has come up with an administrative matter way back in 2016, where Justice Hardeles was one of those who approved it with regard to the 24-month period, Your Honor. I think it's subject to regulation, implementing rules.
According to one justice, there was a resolution by the court that it is only directory, so you do not agree to it. Justice?
Yes, Your Honor. I think that's one of the more recent rulings. The rulings in the 80s and the 90s have said that it is supposed to be mandatory, Your Honor.
Mandatory. I asked that not because it was caused to us by Justice Hardelesa. It's also because trial court judges are complaining that why should they be treated differently because of that ruling that it is merely directory with respect to the Supreme Court and mandatory with respect to them, although they can ask for extensions.
Well, I can sense their frustration at the rulings of the court, Your Honor. But
yes,
if I were to be given the task of laying down what the Constitution really means, then I would definitely say that these are mandatory provisions and everybody should be treated alike, Your Honor.
I see. Do you remember the case of involving Article 992, the Iron Curtain rule in succession?
Yes, Your Honor.
Oh, what happened to that case?
It's still pending, Your Honor.
It's still pending. You are not deponent, or are you deponent of that case?
I am not, Your Honor. It is Justice Marvin.
I see. It was just coursed through me. Anyway, another question by another justice. This is by Justice Brion. He said, what is your most significant ponencia and what is its contribution to the country, to the Supreme Court and jurisprudence?
I would like to believe that the opinion that I wrote for the court in Manila versus Secretary of the DENR is a very vital piece of jurisprudence, Your Honor. It concerns our environment. It introduces the new doctrine of public trust in our shores. By public trust when it comes to environment is meant that the state is trustee of our natural resources, and the state holds it for the benefit of our people who are the beneficial owners. And it is for the state to always see to it that these natural resources are properly conserved and preserved, not only for the current generation, but also for the future generation. That case involves an application of the penalties that are found in the Clean Water Act, wherein a concessionaire who fails to connect septage and sewerage facilities would face fines or imposition of fines, Your Honor. And that is exactly what the court did in the case of Manila and Manila Water.
Yes. Okay. What else? Do you have any other significant ponencia?
I would like to think also that my ponencia in the case of Mary Jane Veloso is a groundbreaking one. Even before the revision of our rules of civil procedure with respect to the use of the deposition-making processes, the court, by virtue of an application or suppletory application of the rules of civil procedure, applied the mode of discovery of deposition in the case of Mary Jane, who was then, or who is still incarcerated in Indonesia and is facing the death penalty there. What happened, Your Honor, is that when Mary Jane was found to have been carrying drugs in Indonesia and was arrested there, the authorities here in the Philippines, on complaint, arrested her recruiters, and they were charged with illegal recruitment in the RTC of Nueva Ecija. And the recruiters, there are two of them, had opposed the application of the prosecution to use as witness Mary Jane Veloso. They wanted to utilize her testimony, which they wanted to secure by way of deposition, and the RTC granted it. On appeal to the CA, Your Honor, the Court of Appeals said that it was grave abuse of discretion for the RTC to apply suppletorily the rules on civil procedure. And so the prosecution through the OSG elevated the case to the Supreme Court, and eventually we came up in the third division with our ruling, wherein Mary Jane's condition is akin to that of a witness who is unable by all means to testify because of her incarceration in a foreign country. We felt that it was the duty of the court to extend fairness and justice to Mary Jane by applying suppletorily the rules on civil procedure with respect to deposition taking, Your Honor.
Okay. This is a question from Chief Justice Davide. How would you address the lack of courtrooms in the country? There are so many judges being appointed, but there are no, or the number of rooms are not being, or the problems of the courtrooms are not being addressed.
Firstly, Your Honor, I think the Hall of Justice Department or office in the Supreme Court has to be expanded. The personnel there is very, I think, inadequate. We don't even have architects in our Hall of Justice Department who can extend their expertise when it comes to the construction of the Hall of Justice. There is underway, Your Honor, a review of the plantilla with respect to the Hall of Justice. Chief Justice Peralta wants that the whole of Justice Department be expanded in such a way that it can cater to all our halls of justices in the country, even those that have yet to be constructed. In one of my long-term plans for the judiciary, Your Honor, I adverted to land banking. By this, I mean that the court should accept as many donations of flats as possible from LGUs where we can construct halls of justice which would have very distinct features such that once an ordinary person comes before it, he would realize easily and recognize it as a hall of justice. So I would want that we would have halls of justice that will be built all over the country, but on separate locations, Your Honor, quite apart from the city hall, apart from the, or separated from the provincial government office, etc., etc. So we would need to coordinate in that respect also with local government units, Your Honor, because most times it is the LGUs that get to donate these properties. Obviously, the court has no funds for the acquisition of these lands. We can only look to donations and the generosity of local governments. I can cite the province of Rizal, Your Honor. It came to our knowledge from Justice Peralta, Chief Justice Peralta, that the province of Rizal, or I think it's Antipolo, is donating 25 hectares of its property where a hall of justice and other facilities for the court can be built on. I think the Antipolo, the city of Antipolo is even spending for the hall of justice there. So we would have to coordinate not just with the LGUs. I think we would also need to look at Congress for support, Your Honor. Our budget at the moment has for the first time reached more than 1%. That's in 2019. In previous years, it has never gone beyond 1%. And in 2019, for the first time, the judiciary has been given a budget of, I think, about 1% of the entire appropriations for the government. I think we would need to really impress on our Congress that our courts need to be funded, especially when it comes to the laying down of vital infrastructure like halls of justice, automated innovations like where it would involve giving security to our court personnel, our judges, like CCTVs, Your Honor. In many countries abroad, halls of justice have CCTVs. They have full functioning electronic systems where they can see threats to the courts. So I think that would be one way of addressing the problem, Your Honor.
Okay. Earlier, you said that should you be appointed as the Chief Justice and the chairperson, automatically the chairperson of the JBC, you would want that the best and the brightest be nominated. Okay, and now Justice Joey Reyes has suggested that those coming from the outside, from the private sector, even from academia, that the PhilJA create a one-year course that will focus on the ethical values and internal rules in the Supreme Court and the latest administrative circulars. What can you say about this?
I wholeheartedly agree with that, Your Honor.
You agree with that?
Yes. In fact, what I have in mind, Your Honor, and connecting it to my plan for the PhilJA, is that PhilJA be converted into an institution of higher learning, where it can grant degrees or certifications or masteral degrees to those who would want to transition to service in the bench, Your Honor. I would think that 6 months to 1 year of judicial training would be very vital in the recruitment of the best and the brightest. And if that were to happen, I think that it would help a lot in the decongestion of the court and in impressing upon the public a court that is very responsive, very competent, and very efficient.
Okay, he also suggested that a physical space for meditation and reflection, such as a prayer room, be provided. Is that feasible or constitutional?
I would not think that it would involve a constitutional issue, Your Honor. I think that would be something that our workers in the judiciary would need. Mental health is something that and spiritual health are matters that really would need to be addressed by our courts, Your Honor. Every workplace has to have a place where every employee can be given the time to think about what his work is, what his work is, what his life is in government, etc., etc. I think that's a very important part of every workplace.
On the part of Chief Justice De Castro, she wanted to ask about how would you implement the enterprise information system plan or improve on it, the EISP. Are you aware of it? I'm sure you are aware of it because you have been in the Supreme Court for a longer time.
Yes, Your Honor. The way I look at it, it's ideal. It's ideal at the moment, Your Honor. Its implementation has, I think, in many ways, laid out what it was meant to be, and it can only be subject to review in the future if there should be glitches, Your Honor. It is only when there would be the passage of time that we can see that there would be complications in the system, and I think that's the time when we would have to review it.
Okay. We'll now go to the internal rules. You have been in the Court of Appeals, and we are both aware how the cases there are equalized, the initial caseload. Now, the rule in the Supreme Court is different. When you inherit a caseload below the average, your cases are unloaded to you. The problem is, I think you are aware of this. The problem is in case the load you inherit is more than the average, and you are stuck with it. It happened to Chief Justice Bersamin, and when he was interviewed for the position of Chief Justice, he declined because it would affect him or benefit him. What can you say about that rule? Should it be revisited?
Yes, Your Honor. It also happened to me.
Yes, because you inherited this load.
I am a victim of that very inequitable system of giving a initial caseload to a newbie, Your Honor. In my case, I inherited close to, I think, 1,200 or almost 400 beyond the norm.
Have you made suggestions which are acceptable to your colleagues?
Well, what I did, Your Honor, after waiting, I bided my time. After some months, I came up with a letter to my colleagues that if they may also share in the burden of the heavy load that I inherited. And to their real credit, Your Honor, they agreed. And that is something that really doesn't happen very often in the court.
What is now the rule?
There is no rule yet, Your Honor.
No rule yet.
Yes, but my proposal is that
They are waiting for you to become the Chief Justice. Well, anyway, if you're the Chief Justice, the raffle will be less. The cases raffled to you will be less.
Yes, Your Honor.
Oh,
But I would
think
want
that-
that every incoming justice would have a fair share, an equal share of his initial caseload. Something that's not very burdensome, like what happened to me, Your Honor.
Oh, because maybe because you're still young. Anyway, this is a question phoned in or texted from the media. Search warrants issued by judges have been used to arrest and detain activists, labor leaders, and even journalists. Worse, critics say search warrants have been weaponized that led to the killings, including the March 7 Bloody Sunday with 9 progressive leaders killed. How do you respond to calls to review the rules on search warrants? You know, I was also a judge of a heinous court in Quezon City, and I was also the executive judge. The executive judge in Manila and I were uh, resolving the search warrants uh, applied for in the case of Manila by the MBI, and in my case in Quezon City by the PNP. Okay. What can you say to that on the question posed by the
Well,
the question is how do you respond to calls to review rules on search warrants?
well, I think that every rule needs to be reviewed every now and then, Your Honor, so that in order for our courts, especially as in the Supreme Court, to see that, well, there would need for that because there are irregularities in the issuance. But I think that with respect to the process itself, Your Honor, there is nothing wrong there with as long as the judge has really been convinced by the quantum of evidence needed to issue the search warrant. If he really issued it on the basis of what our rules really require, then I think the judge should not be blamed for that. But if
after searching questions on the basis
yes,
of the affidavit and searching questions.
Yes, Your Honor. But it's a different thing when it comes to the implementation of the search warrant.
That's a different. No,
Yes,
it's not.
because then
That's beyond the judiciary already.
yes, Your Honor.
Yeah. Oh, there
I think
is
that
a principle of judicial stability, wherein judges, equal courts cannot interfere in the orders or in the cases being handled by a co-equal court. What can you say to that? Because we have been hearing that some cases being or orders of some judges are being restrained by other judges from other jurisdictions. What can you say to that?
I think that amounts to gross ignorance of our rules, Your Honor. If those reports would be validated, then I think those judges would have to be sanctioned administratively by the Supreme Court. There is nothing more important than stability among co-equal branches of the courts, Your Honor. Only an appellate court can possibly, validly review an action of a lower court, and not for a co-equal court to review and even supersede the orders of another.
How about the findings of a court issuing the search warrant being reviewed by the court actually hearing the case? What is your view on that?
The I think I find nothing wrong with that, Your Honor, because the
Nothing
initial
wrong with that.
action, yes, it's a different
Can you
thing.
explain? It's a
Yes, Your
different
Honor.
thing. Okay. Oh.
Yes, Your Honor.
Yeah, can you expand on that?
Yes. The matter of issuance of a search warrant would have to undergo the usual process, Your Honor. The judge would only be minded to issue a search warrant if, on the basis of probable cause, he finds that there is need for issuing a search warrant. And if a case is eventually filed in the court of the judge who issued the warrant, then it would entail utilization of the expertise of the judge in adjudication already, Your Honor, because it would mean that he would have to assess the evidence already presented by the prosecution. The objects that may have been returned by the law enforcers by virtue of their implementation of the search warrant would have to be presented by the prosecution for purposes of evidence, Your Honor. And I think
But
that
it's
the
not
judge,
covered by the rule on judicial stability. It's not covered by the rule.
in my view, it is not, Your Honor.
It is not.
Yes.
You were one of the signatories in the resolution expressing the sense of the Supreme Court with respect to the judicial the requirements of the JBC. And we have responded to that and eliminated so many requirements, especially with respect to the Associate Justice of the Supreme Court. There's so many. One of them are the, for example, or two sample decisions, because your decisions are all over the screen already, and those which you have already submitted. Have you received a copy of the resolution of the JBC and Bank addressing the sense of the Supreme Court?
Yes, I have, Your Honor.
Now, what is your opinion on that? In case you become our chairman in the JBC.
I think the resolution is fair enough, Your Honor. And well, if by the grace of God I would get to be chair of the JBC, then I would probably try to get a consensus as to whether the sense of the court can be acceptable eventually or ultimately to the council.
We were also contemplating doing away with the public interviews, but there were so many criticisms. Even our closed door interviews of Justice Carpio and Justice Bernabe, the JBC was criticized for holding the interview, the closed door interview. So we really could not waive that. We're really very sorry, because it's not really for us. We know you personally, but it is the public who is very much interested. That is why our interview now is being seen all over the Philippines to Channel 4.
Yes,
Are you for the interview or for the elimination of the interview, public interview?
It would be part of transparency, Your Honor, on the part of not just the JBC, but for the court itself to have these interviews.
The public should know who the JBC are vetting for the position.
Yes, Your Honor.
I heard you about legal education. There is a bill now pending in Congress. Congressman Veloso is listening. There is a proposal to place the LEB, which is now under CHED, under the Supreme Court, because it is at any rate the body entrusted with admission to the bar. What can you say about that suggestion that it be placed under the Supreme Court, the LEB?
I would have strong reservations, Your Honor. The Supreme Court primarily has adjudicative functions and duties. I think it's bad enough that we are burdened with a very heavy backlog. And here now comes the Supreme Court supervising law schools through the LEB. I would think that would be an overstretch of the definition of judicial power and functions under the Constitution, Your Honor. I should think that that kind of LEB should really stay with the executive branch, much like the Commission on Higher Education, the CHED. It's really for...
Okay, continue, Justice.
It's best for the executive department to have reins over the LEB, Your Honor, in the matter of regulation of higher educational institutions.
Thank you very much, Justice. That was my last question. Good luck and your excuse. Oh no, Justice Congressman Veloso will ask you questions pa. Usually kasi sorry, I'm the last. Pero nandiyan pa si Justice Veloso. And
yes, sir.
Chief Justice Peralta may also ask questions.
Thank you so much, Your Honor. Thank you. Thank you, sir.
Yes.
Thank you. Thank you, Justice Mendoza. The next to interview the candidate will be the Honorable Congressman Justice Vicente Veloso III. Justice Veloso, sir.
Thank you.
Good afternoon, sir.
I will be touching only on 3 topics, but in the light of your reply to Justice Mendoza, I will make it 4. First is Justice Hernando. When do you say that a person is not just a respondent in a case or is not just an accused but a convict?
Well, when he has been sentenced by final judgment, Your Honor, and is now serving sentence in our penal institutions.
So there's a veil of difference between a judgment of conviction by final judgment and the promulgation of judgment by the RTC. Is that correct?
I would think so, Your Honor.
Okay. That said, let me read to you Article 3, Section 13 of the Constitution. It says, all persons except those charged with offenses punishable by reclusion perpetua, whenever evidence of guilt is strong, shall before conviction, emphasis on before conviction, be bailable by sufficient sureties or be released on recognizance as may be provided by law. Okay. On the other hand, we have Rule 114, which says, and I will read in Section 2A, conditions of the bail requirements. All kinds of bail are subject to the following conditions. A, the undertaking shall be effective upon approval and unless cancelled shall remain in force at all stages of the case until promulgation of the judgment of the regional trial court, irrespective of whether the case was originally filed in or appealed to it. So here is our rules of court saying that your right to bail is only until promulgation of judgment. It is another ball game if you would like to appeal your case. Is this not an encroachment of the injunctive right guaranteed and accused by Section 13, Article 3 of the Constitution? There is, as I said, a conflict between Article 3, Section 13, which says that the right to bail shall be enjoyed until conviction. On the other hand, our provision on bail, Section 2A, says it shall be only until promulgation of the judgment. Your Honor.
That's one perspective that's new to me, Your Honor. I would think that we would have to clarify that in light of what our Constitution provides. And I think that in that regard, we would need to review our rules, Your Honor.
Okay.
To be honest, it's my first time really to look at it that way.
The second topic is about, again, the disposition of cases. Remember that Article 3, Section 16 guarantees, again as an injunction against the state, that all persons that right to speedy disposition of cases. And Article 8 complements that by saying Section 15, Paragraph 1, lays down the period within which to decide a case that has already been submitted for decision. 24 months for Supreme Court submitted decisions, cases that have been submitted for decision, 12 months for collegiate courts, and 3 months for all lower courts. And as you earlier admitted, Paragraph 4 of Section 15 expressly provides that the period to decide is both mandatory and punitive. Punitive in the sense that the Constitution says without prejudice. Okay. Now, but you have, in reply to the question of Justice Mendoza, said that while it is mandatory, it is not self-executory. I am perplexed by that because when you say there is no implementing rule yet, Article 8, Section 1 of the Constitution says the judicial power shall be vested in one Supreme Court and in such lower courts. This has been implemented despite the absence of any implementing rule. And if you take a look at Sections 2, 3, and 4, and even 5 of the Constitution, of Article 8, they speak of mandatory provisions, yet they are being implemented without need of an implementing rule. Let me read to you, Your Honor. Section 1, the judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. It says shall, it's mandatory. Section 2, Congress shall have the power to define, prescribe, and apportion the jurisdiction of various courts but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 4. 5. This is being implemented by Congress without any implementing rule. Section 3, the judiciary shall, again mandatory, enjoy fiscal autonomy. And we in Congress have been respecting this without any implementing rule. Will you still insist, Your Honor, that this provision in Section 15, Paragraph 4, which says it is mandatory in relation to Section 15, Paragraph 1, on the period within which to decide the case, cannot be implemented by the Supreme Court?
I'm not saying that, Your Honor, that it cannot be implemented. There is nothing inconsistent with what I said. The period is mandatory, the 24-month period. And courts would have to, the Supreme Court would have to abide by that. And also the appellate courts with respect to the 12-month period. And the first and second level courts with the 3-month period. The period itself is mandatory, Your Honor. But with respect to the matter of determining when it shall reckon or when it shall commence, then that's subject to guidelines, Your Honor, which is what exactly the Supreme Court did in Administrative Matter number 16-0403-SC, which is entitled Guidelines on Determining the Reckoning Point of the Period to Decide or Resolve Judicial Cases of the Supreme Court. One of the signatories to this administrative matter, Your Honor, is Justice Francis Hardalesa, who had raised this matter before the Council. There's really nothing inconsistent with what I said, Your Honor. When it comes to the period itself, it's mandatory. Obviously, we cannot make that longer. We cannot make it shorter. But with respect to the lower courts, we can shorten that because that is what the Constitution provides. It is not for the court to determine whether this period is in some of its rulings permissive. I would think that the period itself is mandatory. And I'm only saying that with respect to when the period will start, then it's not self-executing because we need to have guidelines, Your Honor. That's what I'm saying.
Speaking of guideline, Section 15, Paragraph 2 says, a case or matter shall be deemed submitted for decision or resolution upon the filing of the last pleading, brief, or memorandum required by the rules of court or by the court itself. In fact, Paragraph 3 says, and this is what we have been doing when we were with the Court of Appeals, upon expiration of the corresponding period, a certification to this effect signed by the Chief Justice of this Court, Supreme Court, or the presiding justice in the case or presiding judge shall forthwith be issued and the copy thereof attached to the record of the case and served upon the parties. The certification shall state why the decision or resolution has not been rendered or issued within said period. So, in relation to the explanation you gave that the Supreme Court can extend the period within which to decide, is that benefit not obtainable by judges in RTC or lower courts or by justices of the Court of Appeals?
Your Honor, I have to repeat that the court cannot extend that period, 24-month period, insofar as the Constitution is concerned. But there may be circumstances beyond the powers of the courts in which they cannot, beyond any human skill, really come up with a decision within the period. So there have been instances where the court has allowed extensions by judges, but only within a very limited period of time. I think, Your Honor, that with respect to lower courts, the Supreme Court has a duty really to see to it that our judges and justices comply with the Constitution. But at the same time, the court has to recognize that there are factors beyond the control of our judges that bar them from complying with these periods. And as long as they can come up with justifiable and very acceptable reasons, then I don't see any reason why the court would not grant the extension. Because after all, we're not really after coming up with decisions within the period, but we are after coming up with decisions and judgments and adjudications that are fair, that are in accordance with evidence, that are in accordance with the rules, and the like, Your Honor. So I'm not really saying that we can do extensions for our courts with respect to the provision in question.
In fact, as I was saying a while ago, the punitive aspect of that is that paragraph 4 of section 15 says, despite expiration of the applicable mandatory period, the court, without prejudice to such responsibility as may have been incurred in consequence thereof, shall decide or resolve the case or matter submitted thereto for determination without further delay. Now, that without prejudice clause, in essence, justified the punitive actions made by the Supreme Court against erring judges, against erring justices of the Court of Appeals. But let me go to the Equal Protection Clause in Article 3, Section 1. While the first part of Section 1 says no person shall be denied deprived life, liberty, or property without due process of law, second part says nor shall anybody be denied equal protection of the laws. So, in my view, the benefit you enjoy as justices of the Supreme Court should be the same measure of benefit, protection, that should be enjoyed by the judges of the lower courts and by the justices of collegiate courts. Do you agree with me, Your Honor?
I would say, Your Honor, that equal treatment for all should be the norm. In that aspect, I would agree with you.
In fact, I am worried on the part of the Supreme Court because we have in Article 11 a provision on impeachment, and one of the grounds is culpable violation of the Constitution. And the definition of culpa in the revised penal code is, it says, by negligence, culpa is fault by which one should suffer. In fact, Article 204 of the revised penal code says, this refers to the dolo aspect of it, knowingly rendering an unjust judgment would be make a judge answerable for that. And Article 205 of the same revised penal code says judgment through negligence. By intent or by neglect, there is a culpable violation of the Constitution. So I hope that the Supreme Court will take a look at it and please fix your house, put it in order to shield very brilliant justices of the Supreme Court from this problem. We in Congress have a lot of problems also about the Constitution. But while we would like to come up with a law that would be averse to what the Constitution provides, we cannot do that because we all know as lawyers that only an amendment of the Constitution will solve our problem. Let me go to the third point, Your Honor. Republic Act 6713 refers to Code of Conduct and Ethical Standards for Public officials. Here, a lot of questions were made about SALN. All three branches of government are required, all employees, officials of the three branches of government are required to submit their SALN, sworn statement of assets, liabilities, net worth. There is an issue of whether or not the legislative department can be compelled, following your example, can be compelled to open its door to people who would like to say harass, especially members of Congress or politicians, to harass members of Congress. But we have Section 10, paragraph B, which designated the committees of both houses, quote, to render any opinion interpreting the law. Therefore, if the interpretation of Congress is that to protect us from this harassment maneuverings of opponents, we come up with a rule, and we in fact have a rule that you just cannot compel any congressman to show his SALN without prior approval of majority of the members of Congress. If that question goes to the Supreme Court, and in particular, especially that Section 12 says that nothing in this provision, meaning this act, shall be construed as a deprivation of the right of each House of Congress to discipline its members for disorderly behavior, meaning it is not for any other department to discipline any member of Congress for failure to submit SALN on time or whatever. If this matter goes to the Supreme Court, would you be, under your leadership, be willing to come up with a policy that would compel Congress to open its doors to any party whose purpose is contrary to morals or public policy, and he is not part of media, to get a copy of the SALN of a member of Congress?
If there would be such a law, Your Honor?
We have I am quoting a provision of section, paragraph B, Section 10, as well as Section 12 of Republic Act 6713. The protection is right in the law itself.
Yes, Your Honor. In fact, that's the basis for the court's adoption of certain measures before anyone can get a copy of the court's SALNs.
Okay, on the promulgation of rules concerning the admissions to the practice of law, you have, well, this has already been quite discussed by previous interviewers. I think, Mr. Chair, that would be all for this representation. And good luck, Justice Hernando.
Thank you, sir. If I may just give an assurance to you that in the Supreme Court, we are not being negligent with our work. We are doing the best that we can, Your Honor. In fact, each one of us brings our workload at home just so we can come up with decisions. And I don't think that anyone can accuse us of being negligent when it comes to the kind of work that we do at the Supreme Court. Thank you, Your Honor.
Mr. Chair, I'm done.
Thank you. Thank you, Mr. Justice Veloso. Mr. Chair, that concludes the interview of Justice Hernando. The Chief Justice will no longer interview Justice Hernando.
Hindi na si Chief, no more.
Justice Hernando,
Oo,
sir,
sige, that will be all.
Thank you, Your Honors. Thank you, Attorney Ed.
Oh, thank you very much. Oo.
In fact, Your Honors, that will
Wala.
conclude the public panel interview by the JBC of candidates for the position of Chief Justice of the Philippines.
Okay. Sa Monday, see you Monday.
Po, Justice.
Ay, Tony Ann.
Po.